We want that some order should be passed regarding the modification.
No, day after tomorrow for what purpose?
Purpose is this, my
No,
lord,
what stage?
we want that the case may be listed for admission.
Admission, 15 matter not admitted. How is it
Yes,
possible?
sir. So I think that there is no interim order. So that's why we are in
We can have it for orders. For orders.
Yes.
15 matter, okay. For orders.
15.
May I please, your lordship?
Yes.
I have prepared for listing of transfer petition.
Fresh matter.
It's a fresh matter. It will come as a motion.
Okay, whenever you want.
Day after tomorrow.
I have a similar transfer petition for motion day after tomorrow, my lord. I have one more prayer, my lord, for district of MSc appeal for orders, my lord.
Appeal of which year?
My lord, it is appeal of my 2019, my lord, for orders. Any date, my lord. Thursday. Oblige, your lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 63 of supplementary list.
63.
Yes, my lord. In this case, we are direct to file some additional documents which we are going to file today.
Okay. Year
So-
for whom?
I am for the petition, appellant, my.
Appellant.
Told lordship.
Okay.
My only prayer, lordship, the date may be fixed. 19th or 20th June.
When? Tell us.
19th June.
A prayer for adjournment has been made on
Yes.
behalf of the applicant. Full stop. As agreed to by the parties, list on
19th, my.
19/6.
May it please.
Hello.
Yes.
Oblige.
May it please, your lordship. I beg to mention item number 8.
8 years.
Because of the personal inconvenience of the petitioner counsel, this matter may be taken up next week.
Who is the counsel?
P. Sotri.
Okay. Next week, taking the consent of the other side.
Yes, I've taken.
Okay. On a prayer made on behalf of the petitioner, list after a week. Yes.
May I please, lordship? I beg to mention item number 28, my lord.
2/8.
28, my lord.
Yes.
In this case, I may be allowed to file appropriate application for withdrawal of our Bakalatnama, my lord.
Okay. You're for the petitioner
Yes, my
otherwise.
lord.
Your name?
DJ Med.
Sri DJ Medhi, learned counsel for the petitioner submits that he and his associate would like to withdraw from this case as counsel. Full stop. He accordingly prays for and is granted a week's time to
2 weeks.
file appropriate application for withdrawal of Wakalatnama.
My lord.
2 weeks. 2 weeks time.
May I please, your lordship?
Yes.
Lordship,
Have you informed Mr. Medhi? Other side has been informed.
No, my lord.
Make a mention. Make a mention only after we informing, not like this.
It is not complete, my lord. Yes.
Somebody has appeared.
Yes.
Item 28, isn't it? We find names of
Lordship, I
counsel.
will-
You inform, then you have the order, not like this. Don't make a mention. Yes.
Lordship, I beg to mention item number 45.
Yes.
Lordship, my senior B Pusita is unwell.
40.
45.
Who is not well?
B Pusita.
On the respondent.
Yes, Lordship.
Okay, inform the other side.
Lordship, I informed the phone switch off.
Then you
Actually-
cannot entertain a mention. You have to wait for your turn. We'll accommodate you, but not now. Okay.
Okay, Lordship.
May I please, your lord, lordship, I beg for listing of a CRP matter. It
Fresh
is-
matter.
No, lordship,
Matter of which year?
of 2024 only, but here is in the case, we are, the prayer of the petitioner is to set aside the impugn order passed by the Municipal Court of Nagaon in title suit. So in the next hearing, the next date of hearing of the title suit is on 8th of this month, that is 8th June. So
On the
request
first
to-
date, why was the interim order considered?
Yeah, because due to wrong entry of the advocate that was hired by our party in that was the defendant. So because of that wrong entry in his record book, he could not be present in that state. Aforesaid
We are not
court.
on that. On the last date when the matter was considered by this court.
Yeah, the notice was issued. And accordingly we have to take the steps.
When was notice issued?
Notice was issued on lordship. Lordship notice was issued on 1/4/2024.
Returnable by what?
returnable by, returnable on. Hmm? The code is fixed and the returnable is on 5/4/2024.
1/4 it was made returnable 5/4. How is it possible?
No, sorry, Lord. It was on 27/3. I mean, notice was issued on 27/3 of
And
2024.
returnable on?
5/4, 5/4/2024.
What happened on 5/4?
Your Lord.
What happened on 5/4 thereafter?
Thereafter, we have taken the step.
No, 5/4 was it listed or not?
Yes, Lordship, but their names were, the respondents' names were not reflected in the court book. So now,
Oh,
we
see,
are-
these are matters where you have an interim prayer. It was considered and not passed on the first date. Why should we pass it now? Okay, we'll have it Wednesday.
Your Lordship.
But you have to come prepared. You should have your notes on the cover of the file.
Yes,
Every order. Why should you look into the file?
Yes, Lord.
This is not the practice. Whatever order is passed in concise, you have to have in the cover of the file.
Yes, Lord.
So that the moment the court asks what was the order passed on the last date, you should be able to answer in within a second.
Yes, Lord.
Why are you having to look inside the file for a particular date?
Sorry, Lord.
Okay, Wednesday,
Thank you.
Item number 29 of income the arrest.
29. ठीक है.
May I please, Your Lordship? Your Lordship, I beg to mention item number 15 of today's daily list, Your Lordship.
1/5.
1/5. Your
Yes.
Lordship, just now I have been informed by the engaged counsel, Your Lordship.
Yes.
They are stuck in flood, Your Lordship, coming from Belpala. So kindly the matter be adjourned for the day, Your Lordship. Since 1 hour,
Item number 15.
15, Your Lordship.
Okay.
Huh?
On a prayer.
Okay.
Well, she has informed me over phone that she's stuck in
Okay.
Waterloo.
Okay. We'll have it Wednesday.
Wednesday, Your Lordship.
On a prayer made on behalf of the applicant, matter is passed over to be listed on Wednesday next. Okay.
Obligement.
May I please, Lordship? Lordship, there is some urgency in this matter, Lordship. We have filed an CRPIO on dated 4/5/2024. And regarding, we have not been allowed to file our written statement. And this matter has been fixed by Honorable Learned Court below on 6/6.
When have you filed? It's a fresh matter.
Yes, Lord.
When have you filed?
4/5/2024.
Not listed as yet. Not listed. 4/5 till now, not listed, almost a month. Why? Is there any defect in the filing?
Yes, Lord.
Was there any defect in the filing? Defect was there. Have you rectified?
Today,
If you have not rectified, how can you make a mention? You have to file it in the proper manner, then you make a mention, we'll help you. Remove the defect and make a mention tomorrow. We'll consider.
May I please, the Lordship, with the consent from the other side, I beg to mention item number 58. Matter may be listed after 1 week, Your Lord.
58
58, Your Lord.
of the main list.
Yes, Your Lordship.
Hearing matter.
Yes.
Why is the hearing matter? 23 matter. Okay. 58. Oh. On a prayer made on behalf of the petitioner, list after a week.
Lordship, a date may be given at 40.
You are making an adjournment prayer and you are asking for a date. What is this? Do it today. 1 week. Yes.
It's related to a domestic violence matter, my lord. And
Come this side. Yes.
it's a domestic violence matter, and it's going on in the Boko court since 2019. And the aggrieved has suffered a lot, and now her daughter, she is quite bright in studies, so they have shifted school to Guwahati. So she wants to shift the case as well, to transfer the case to Kamrup Metro.
You are the wife.
Yes.
Wife you had filed where?
It was filed in the Boko court, Boko subdivisional District Court. And it's very inconvenient for her to keep moving, going to Poco now, now that the
No,
minor
you had
daughter is
filed on
studying
your
here.
own volition.
She was living in Boko at that time. Now, because of her daughter's education
Now,
and her,
can it be at your convenience? You file it here, tomorrow you have an inconvenience, then you go to another court.
no, but now that,
You are not the respondent, you are the petitioner.
but if notice is issued, the respondent also lives in here. We have filed the address of the respondent, the Guwahati address of the respondent. as
Has
well.
the respondent approached this court for a transfer?
Not yet, but if notice
Then-
is issued, if with their consent, if it can be moved. Because it is very difficult. to
Madam, is it by transfer, is it by consent? What are the provisions of transfer?
The provisions of transfer is that when there is.
Where is the provision? Which act? Which
under
act
the
will be
High Court rules,
applicable?
madam, under the High Court rules, ma'am.
High Court rules, transfer,
I'm not carrying it at the moment.
High Court rules, just show us the rules. Madam, don't come like this, a transfer petition, move it, get an order, it's not like that, it's not so easy.
It's not that easy. I agree.
So where are the rules?
I should have brought it with me
Get the rules, we'll have it day after tomorrow.
day after tomorrow. Yes.
Okay. Honor prayer made on behalf of the petitioner. List on Wednesday.
Thank you. Obliged.
Item 2.
May I please, Lordship? My lord, the predecessor interest of the present respondents filed a title suit at Borpeta Municipal Court, my lord. In that case, my lord, I was respondent, I am defendant number 3, my lord. But at that relevant point of time, I was living at Guwahati for work, my purpose. Then, my lord, some person put signature in the Wakalatnama and Hajiras, etc. Put signature thumb impression. And the learned Munshib also took the same seriously, and the notice was presumed as served. Then, my lord, some order was passed ex parte against the defendants, including me. I am the defendant number 3. Then, my lord, after some days, the persons from court came to give possession to the decree holder. Then only I came to know that there is a decree ex parte passed against me also. Then, my lord, we filed a petition immediately before the learned Munshib. But the learned Munshib, Lordship may kindly say, learned Munshib passed an order rejecting my petition that may be seen, my lord, page 22.
22,
Yes,
22.
yes, 22. And extra 2.
Yes.
Operative portion, Lordship may kindly say, is 25.
No, 22 is the judgment.
Yes, this is expertise.
No, you said you had filed an application.
No, I have filed application. Application I have annexed also, but I am reading the order of the learned Munshib which was passed on my application.
Yes.
So that may be seen page 25 operative portion. The suit is decreed ex parte with cost with the following relief to the plaintiff. So
Yes.
this was the relief provided to the plaintiff.
Yes.
And my petition, Lordship may kindly see, but petition I have filed that Lordship may kindly see page 34.
You filed an order 9, rule 13
Yes.
for setting aside.
Setting aside. The learned Munshib, my petition, I have described everything, my lord,
Yes.
that my lordship may kindly see page 34,
Hmm.
where 2 onwards,
Hmm.
that the said suit was filed in respect of land measuring 5 bighas covered by the
Yes, where is the order?
order that I have already, that is page 22.
No, order passed in your petition.
In that application, this order was passed. By
That
learned
is the
Munshib.
judgment.
No, that is, that order may be seen page 37.
You're challenging that order only.
There are 2 orders, my lord. Let me see, page 37.
Yes.
And learned Munshib passed the
What is the
order.
date? 4/12. 4/12?
4/12/17.
17.
Yes. There are some stories I will tell before lordship. Now, the learned Munshib said that the petitioner has submitted that he never received any summon.
Petition rejected.
Rejected.
Then,
my lord, I filed an appeal
yes,
before the learned civil judge at Borpeta. That lordship may kindly see page 38 is my appeal.
yes.
On that petition, my lord, the learned civil judge passed order that may be seen page 41.
Yes,
Then operative portion of that order may be seen, that is appellate court's order, page 45. Hence, from the top I am reading, hence when the matter is very glaring from the documents on record, it cannot be said that the ex parte decree is illegal and is liable to be set aside. Defendant number 3, appellant, has been negligent in approaching the court at the right time for redressal of his grievances, and also is at fault for not filing written statement when 2 petitions allowed him time in TS number so and so. The lastly, my lord,
appeal dismissed.
that dismissed, appeal was dismissed. Then, my lord, we file an petition, appeal, that is page 47, my lord,
Before this court.
before the Honorable High Court. And the Honorable High Court passed some interim relief, that is page 47, bottom.
First appeal against which order?
Yes, that was the mistake. That was discovered later on. So that's why that was withdrawn.
What
But
is-
relief was provided to me.
Just a minute, please.
Page 47, bottom.
Just a minute, please. Yes,
Now, Lordship may kindly see page 47, bottom. At the time issuing notice, some relief was provided, that is bottom, till the returnable date operation of the expertise judgment
Hmm.
and decree that is so and so passed in title suit number so shall live in state.
correct.
So that was continuing, thereafter it was extended. And the fine, that is on the last, when the case was listed on 13/5/24, Lordship may kindly see page 50. Then it was discovered that appeal was filed in a manner, in a wrong manner.
Hmm.
So there is a judgment of our High Court that mentioning of wrong provision of law does not debar a person from getting justice. Even then, we did not raise any objection because our intention was to get relief. Now, page 50, Lordship may kindly see, bottom, taking into account the above submission.
Yes, we have read this.
So that was withdrawn with liberty.
Hmm.
Then this petition has been filed. Now my prayer is this, if your Lordship kindly see the grounds of this filing CRP, that Lordship may kindly see page 8. This is normal, but page 9 may be seen. Roman 3, page 9, Roman 3. The learned court not properly conceived the provisions of order 5 rule 19, that is our one ground, and sufficient we have explained that I did not receive. Here the important question is this, my lord, I know how to put my signature. I am not a so learned man, but I can put my signature. But in the Wakalatnama, Hajiras, WS, etc., all were thumb impression. Then it was a mistake on the part of the lower court counsel. He should have paid that it should be sent to forensic expert, but he did not pay. But that is, my lord, expert evidence is weak. The other evidence are we have adduced that I am not that person who put the thumb impression. So courts his own motion also can send it. And our submission was, clear submission was that Jarikarak was not examined. When my case is that I have not received notice, it was the duty of the learned court below to take evidence of Jarikarak so that I may cross-examine him, how he came to the conclusion. He said that that was kept in the house. So that house, I reside at Guwahati, whether that house belongs to me or another person. And my brothers, they are the party in this
See,
case.
the original degree is not put to challenge in any appeal.
My lord, actually, thing is this, my lord,
Now, how do you overcome the restriction of 115?
no, my lord, my submission is there, we have under 115. Now, thing is this, my lord, there may be there are three conditions of 115. The learned court did not exercise jurisdiction or exercise jurisdiction in a wrong manner, which has caused material miscarriage of justice. And thirdly, the learned court failed to exercise jurisdiction in a manner which has to be done. Here, my lord,
Mr.
thing is
Mahmood, you
this-
have not read the most important clause inserted. These are the points of exercise of jurisdiction. What is the fourth clause, which is the most important clause in 115?
No, there are three.
Not three. All three are governed by the fourth clause, which is most important.
But we are in motion stage, lordship, my lord.
No.
Let
No, no.
us,
On the maintainability.
let
we
us satisfy, my lord.
Yes, you have the CPC. Where is the CPC?
It is the story I have not.
You don't bring CPC also. We'll have you give your CPC. What is the insertion by the amendment? Hassan, your CPC? You have missed out the entire essence of the amendment of 1999, which came into effect from 2002.
My lord, 115.
Yes. After the three ABC,
Yes.
then you read the proviso.
Provided that the High Court shall not,
Shall
under
not,
this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding except where the order is, if it had been made in favor of the party applying for division, would have finally disposed of the suit or other proceeding. So, my lord, my understanding to this proviso, I understand that.
if your application was allowed,
Yes.
would it have disposed of the suit or proceeding finally?
No,
Not
only
at all.
so far it relates to me, my lord. So far it relates
It
to
will
me.
have reopened. You cannot. You have a provision for filing an appeal against the decree, which you have not filed.
No, if
You have
because-
put to challenge the order by which your order 9 rule 13 petition has been dismissed.
Yes.
Only an appeal before the appropriate court. You have not put to challenge the decree.
That was not done. That was not done. But thing with this, my lord, that is a consequential decree, consequence of an judgment.
Judgment has to be put in a challenge.
Yes.
We are not on the expression decree or judgment. You have not put to challenge the substantial judgment. You have only put to challenge an order by which your application was rejected.
Then, my lord, I may kindly be allowed to file additional affidavit on this division.
No, that will not change the condition.
The additional affidavit so far regarding proviso, my lord, that
No,
can be.
this will not be improved, cannot improve by an additional affidavit.
No, my lord, my submission is this, so far I understand, petition. but it-
Ideally, you should file an appeal with a delay condemnation. You can cite the reasons that
Sir.
your
34.
order 9 rule 13 was disposed of,
The
then
delay, my lord, delay is, our High Court has several decisions. For the purpose of delay, separate.
no, we are not on the aspect of delay in this proceeding. If you file an appeal tomorrow, it will obviously be barred by limitation. So you can take hold of the, recourse to the order passed in the earlier proceeding where your appeal was withdrawn, 13/5/2024. Some observations has been made by this court. Take help of those observations. Prefer an appeal. Today, you will be getting
But I
nothing.
invite your lordship kindly come to page 34 for a moment.
3-4.
3-4.
Yes,
Here our application was that by the petitioner, an application by the petitioner,
yes.
defendant number 3 under order 9, rule 13, reduce section 151 of CPC.
Yes.
So 151, when it is given, if there is even some lacunas, I think the court may exercise its inherent power.
Mr. Mahmood, we are not on that. The order passed in the in your application under Order 9 Rule 13.
Yes.
To challenge that order in way of a revision, there is a bar which you have initially challenged this order by way of an appeal. That is okay. Appellate court has gone against you. Now we have come to this court by virtue of revision
Yes.
without challenging the initial judgment and decree.
That liberty then Lordship may kindly.
You
give it
file
to
an
me.
appeal that I think is already given in the earlier order. Let me see.
No, my lord, before the learned court below, we may file that petition because there
No,
is.
not before learned court below. You have to file appeal before the appellate authority. Not in the same court. The initial appeal which you had preferred was only against the order passed in Order 9 Rule 13.
Lordship is indicating civil judge, senior division. Barpeta.
Whichever is the appellate authority.
Yes. Then Lordship may kindly
Let
observe.
us see a delimitation part. Let us see.
Well, that may kindly be observed. Otherwise,
This
same
court
question will arise.
shall be explored and competent. Delivered file application. Okay, I think some observation has been made in page 51, paragraph 4 by this court regarding limitation. You can take help of that.
Definitely I will take, but
Take help
Lordship may
of that.
kindly
Okay,
observe that.
okay,
I will definitely take.
Third, Sri M. U. Mahmood, learned counsel for the petitioner. Full stop. Considering the subject matter involved and the provisions of law, comma, the instant petition is disposed of, is taken up for final disposal at the motion stage itself. Full stop. Para. Para, please have your seat. The projected facts are that in title suit number 322 of 2010, instituted before the Court of the Learned Munsif number 1 at Borpeta, comma, the present petitioner.
By the predecessors of the present respondent.
The present petitioner was arrayed as the defendant number 3. Full stop. The said suit was instituted by the predecessors of the present respondents. Full stop. It is contended that while the suit was instituted at Borpeta, comma, the petitioner was residing at Guwahati.
Yeah.
Full stop. It is further contended that there was recourse to some fraudulent activity so far as the report on service is concerned, and according to the petitioner, comma, he never received any notice.
He knows how to write, but there is the
Notice, full stop. It is submitted that the petitioner, being illiterate, comma, though a thumb impression was appearing in the report, comma, there was some fraud involved and the petitioner was actually not having any knowledge of the suit. Full stop. Para. The suit was ultimately decreed wide judgment and decree dated
13/12/23.
13
13.
12 2020 2013,
23.
which was ex parte against the present petitioner. Full stop. Para. The petitioner had accordingly filed an application under Order 9, Rule 13, which was registered as Miss J case number 13 of 2015. Full stop. The said application was, however, rejected wide order dated 4/12/2017. Full stop. Para. The aforesaid order of rejection was, however, the subject matters of Miss Appeal number 4 of 2018, instituted before the learned civil judge, comma, Borpeta. Full stop. The said appeal was, however, dismissed wide order dated 20/10/2022. Full stop. Para. Being aggrieved, comma, the petitioner had, however, preferred an FAO in this court being FAO number 1 of 2023. Full stop. Para.
And got some interim protection.
We're dictating, Mr. Mohan.
Right.
Please have your patience. Para. Without going into the aspect of the maintainability of such appeal, comma, this court has noticed that while an order dated 6/1/2023, comma, while issuing notice, comma, an interim order was passed regarding the operation of the ex parte judgment and decree dated 13/12/2013 and the order dated 23/12 and an ex parte judgment and decree passed in the title suit. Full stop. Para. It, however, transpired that when the said FAO 1 of 2023 had come up for consideration on a subsequent date, comma, this court, wide order dated 13/5/2024, had dismissed the said appeal on withdrawal. Full stop. This court has noticed that the wrong provision of law was taken into recourse. Full stop. This court had also made certain observations regarding the limitation period. Full stop. Para. Pursuant to the said order, comma, the instant application has been filed under section 115 of the CPC. Full stop. Para. The aforesaid section 115 was amended in the year 1999, which came into effect from 1/7/2002, whereby a proviso was added. Full stop. The proviso, for ready reference, comma, the proviso is extracted herein below. Proviso to, Para. This court is of the considered opinion that the instant application would be hit by the aforesaid proviso, and therefore recourse to section 115 of the CPC is barred. Full stop. Para. This court has also noticed that the original judgment and decree of the decree dated 13/12/2013 passed in title suit number 322 of 2010 has not been put to challenge as yet. Full stop. Para. Therefore, while this present application is rejected on the issue of jurisdiction, comma, the learned petitioner is given liberty to challenge the original decree, original judgment and decree passed in the title suit in the appropriate court with jurisdiction. Full stop. While if such appeal is preferred, comma, the petitioner would be at liberty to take recourse to the observations made by this court in the order dated 13/5/2024 with regard to the issue of limitation. Full stop.
As well as today, as well as today's order.
Limitation, full stop. The time consumed after the order dated 13/5/2024 till this date may also be taken into consideration.
One fair, madam, that if any petition is filed for interim protection, that may be considered.
First,
So
you have to overcome
we are
limitation.
all always on protection, my lord.
No, first you have to overcome the limitation.
No, if
Without condoning delay, can the court assume jurisdiction? You make a prayer, it will be considered. Yes. Okay, next.
Apply. Hello.
Yes, Mr. Hussain, what is it?
May I please your lordship? It's a contempt petition, my lord, for violation of an order passed by the Court of Judicial Magistrate First Class from Learned Court of Munsif for my lord. In earlier occasion, your lordship, this honorable court directed me to place the status of the case in before the Learned Court below, my lord. And the case was last listed before the Learned Court below on 31st of May, my lord. On
Yes.
that day, my lord, the aggrieved party, who is the respondent herein, is absent who is absent, my lord, and the petitioner is present. The direction, there is several directions by the Learned Court below, whereby the Learned Court below, first of all, my lord, directed the respondents to allow the petitioners to meet her daughter, my lord. That was violated. Thereafter, it was, my lord, direction was given.
What provisions of the contempt of court
Uh,
are you invoking?
Section 10, my lord.
Yeah, let us see. So, here you come, contempt of court. Please read.
Page number 9, my lord. Power of High Court to punish contempt of subordinate courts, my lord. Every High Court shall have and exercise the same jurisdictions, powers, and authority in accordance with the same procedure and practice in respect of contempts of courts subordinate to it, as it has an exercise in respect of contempt of itself, my lord.
Okay, where is the order? Which is the order which you say is being
There are
violated?
several order, my lord, and the last order is at page number, my lord, 107, my lord.
Okay, we'll issue a notice at this.
My
place.
lord.
Okay. Third, Sri M.A.I. Hussain,
MAI.
learned counsel for the petitioner, who by means of this application filed under section 10 of the Contempt of Courts Act 1971 has alleged willful and deliberate disobedience of certain orders passed by the learned Judicial Magistrate First Class Munsif Kamrup within bracket M in review case number 47 M2 Porter public 2019 available. You had instituted this within a year.
My lord.
Okay. Para, this court, by the last order dated 1/5/2024, had directed the learned counsel for the petitioner to apprise regarding the status of the last date fixed before the trial court, which was 31/5/2024. Full stop. Para. Sri Hussain, the learned counsel, has informed this court that on the last date, though the petitioner was represented, there was no representation on the side of the respondent complainant. Full stop. Para. Let notice be issued, returnable on we'll have it on 21st of June. Okay,
This month, my lord.
this month. Can you serve Dusty?
That's a little bit difficult, my lord, because
21st of,
can it be,
then
my lord, after
it'll
21st, my lord?
be on 28th,
My lord.
28th of June. Not registered post, huh?
Hello,
Steps, take steps within 2 days.
my lord.
There are 2 addresses.
Yes, my lord, this address was given by
Take steps on
on
both.
the permanent address, my lord.
Have been both on both the
Both. my lord.
steps be taken on both the addresses indicated in the first title.
Highly obliged.
61 sublease. Yes, Mr. Rashid, what is this?
It means we are the defendants. Title was filed Millard and that was Millard decree expertly. So
You are
Millard,
defendant in the title suit.
my lord. And then Millard not open and then we file an appeal Millard. against that,
Title suit was decreed ex parte.
expert. And then we file an appeal and appeal there is a delay. And delay petition Millard,
Appeal against the ex parte decree.
my lord. There was order rule and that is not there. So Millard appeal
Timbered.
and kindly see Millard.
You filed section 5 application with the appeal.
Section
5 application, limitation section 5 along with the appeal.
That is there, yes. Kindly see that is Millard page 74 order. And accept 5 Millard.
Page
74,
74.
my lord. May I
Yes.
read? 4/12/21, the case record is put up today. Record reveals that appellant had already filed miss case number so under section 5 of the Limitation Act, and the same is still pending for disposal. As such, the same, this criminal, the title appeal will be put and after disposal of the miss case number so.
Yes.
And next order, Miller, kindly speak.
Hmm.
That is a 10/4/23.
Yeah.
The case record is put up today on the strength of the order dated today, passed in miscase number 35/21. Miscase the contention of preliminary. Sorry. By order dated today, passed in case number 35/21. The prayer of appellant for condoning the delay is preferring appeal is rejected. So only one sentence. So appeal in this case is delayed, rejected, then the appeal automatically goes. So my prayer, Lordship, there one sentence, by one sentence, rejected my condoning petition, and appeal automatically goes. So that order is not.
How many days delay was there?
The delay was there, my lord, on.
What was the initial date of the ex parte judgment?
Expert judgment was my lord 19/1/2009,
19/1/09.
my lord.
And when did you file the appeal?
Appeal was filed in 2012, my lord.
2012.
Then it was filed in the court of Miller subdivision. Then in the meantime, Miller, it was transferred to the Miller district judge.
Oh, that is okay.
So,
How many days delay was there?
Delay was Miller 1013 or Miller, that is Miller 1000.
Where is the order passed in 35/2021?
1310 delay.
Now, where is the order passed in the miscase?
Miscase Miller, this Your Lordship.
Where?
Miscase order is no, there is the order, Miller, only one sentence. Yes.
No, there is an order.
No, I was in God, Your Lordship.
It is not possible. You can see the what is the expression used? Wide order passed, wide order dated today, passed in so the prayer of the appellant in condoning the delay is rejected. This is not the rejection order.
No,
Rejection order is in another case, in the mid
Only,
case.
Miller, I also Your Lordship, only right, Miller. But I also asked the
Mr.
party, Miller, to bring the other.
Roshid, you should not do this. First impression, we are also with you, but that is not the impression. That is not the final impression.
I am
There is
also-
an order, Miss
Your Lordship,
Case.
right, I am also. on
Get
the-
the order, get an order in accordance with law. Convince us that the reasons assigned are not fine, are not good, but not in
Then
this
there is
kind.
no order, one sec. Then I need some time Miller, to take.
Take time, but not this.
This Miller,
not
I
the
am also,
order.
Miller, Your Lordship, right, I am also not satisfied with the order. One
And you are coming after more than a year. What is there? 10/4/2023.
Yes, my lord.
I think you have challenged that order. You withdraw this.
No, first I am the instructor, Miller, whether the any other order.
We'll have it on Friday.
No, not Friday.
Friday, you take instructions. You have to withdraw this. Unless you put that order to challenge, we cannot grant you anything, even if you are entitled to. Though the case projected in this application filed under section 115 CPC is that the appeal preferred by the petitioner against an ex parte decree was dismissed on the grounds of limitation. Full stop. Attention of this court has been drawn to an order dated 10/4/2023 passed by the learned civil judge Bongaigaon in title appeal 1 of 2021 by projecting that it is by this order that the Miss J case 35 of 2021 filed under section 5 of the Limitation Act has been rejected. Full stop. Para. A bare reading of the aforesaid order would, however, indicate that while the appeal has been dismissed in view of the fact that the delay has not been condoned, comma, a separate order appears to have been passed in Miss J case 35 of 2021, which, however, has not been annexed nor put to challenge, not put to specific challenge. Full stop. Para. Sri Rashid, the learned counsel for the petitioner, is accordingly directed to seek instructions. Full stop. List this case on Monday next.
No, 14th.
Next Monday. 10th. 62.
Meet Vijay Pastor.
Yes, yes.
I have come against an order, my lord, dismissing my application filed under Order 7 Rule 11A and B. I took up the ground of limitation, my lord. The suit was filed for specific performance, my lord, where I am defended. And the specific performance was for an
Can
sale.
limitation be ground for return of a plaint for 7-Eleven?
My lord, in this,
Limitation can be a ground of defense in the suit. It's a mixed question of facts and law. You have to adduce evidence.
my lord,
But 7-Eleven cannot be invoked.
my lord, that is what has been taken as the plea to reject my application. But I will persuade this honorable court to show that it was an admitted fact wherein evidence was not required. The plaintiff's case was for a specific performance of an agreement executed on 8 December 2015.
You are the defendant in the suit.
I am the defendant in the suit.
Okay.
Agreement
There is a
was
suit for specific performance.
filed in 2022 for an agreement executed on 8 December 2015. Now the executor, my lord, executor, he was given a legal notice for specific performance on 11 July 2017. And this fact is pleaded in the plaint itself about the legal notice. Now, one fact which is not pleaded and which I brought it now before this honorable court is the reply by the then executor, my lord, 11 September 2017, whereby
Reply where?
a legal notice to the
These have to be proved.
my lord, let us forget this 11 September 2017. That 11 July 2017 is admitted. They sent a legal notice for specific performance, and they filed the suit in 2022.
What are the terms of the agreement? Will the notice bar come into operation for calculating the limitation?
My lord, let us not even go by the notice. There is so far as that
No,
says.
we have not seen the terms of the agreement. What are the clauses of the agreement?
My lord, I'll place that, my lord.
Limitation is a good ground you can take up as defense. You prove it, so it will be barred.
When
7-Eleven, how?
when on the face of it, my
No,
lord.
face of it, how? By limitation, can it be a face of it?
Madam, when it is pleaded that it is, they sent a legal notice on 11 July
Show some
2017.
judgment that 7-Eleven can be invoked even for limitation, grounds of limitation.
My lord, I rely upon the judgment of,
Hold on.
in the case of Pukras D. Jain versus G. Gopalakrishna, my lord, 2004, my lord, if I,
2004?
2004.
Yes.
My lord may take the last para, my lord.
2004, 7 SCC.
Paragraph 6, my lord.
1 minute, please.
Paragraph 6.
Oh, just
my-
a minute, just a minute. 251. Kuraj. Paragraph?
Paragraph 6, my lord.
Yes, please.
Section 16C of the Specific Relief Act lays down that specific performance of a contract cannot be enforced in favor of a person who fails to ever and prove that he has performed or has always been ready and willing to perform the essential terms of the
Madam,
contract.
this is not on the 7-Eleven. This you are going into the merits. You have a case on merits, you argue it. Heard.
My lord, so far as 7-Eleven is concerned, there are judgments, my lord, let it,
There are,
let it
show
come
us,
up.
show us a single judgment.
My lord,
Limitation can be taken up with 7-Eleven.
my lord, let it come up day after. Goodbye.
Day after tomorrow.
Huh?
On the prayer
After it.
made on behalf of the petitioner.
6th, my lord. After-
Friday.
No, it can be Wednesday also, my lord.
Wednesday.
Wednesday.
On a prayer made
Definitely.
by MS Goel, the learned concept for the petitioner. List again day after tomorrow.
I'm grateful, my.
I think 4 to 6. 4 to 6. Why is this before this court? No. We cannot take burden of all the matters. Bench fee matters. List these matters before the appropriate bench. I did 7.
Mate, please. Is the transfer petition lodged on the last occasion the respondent has said that they are going to withdraw the cases file here.
Somebody had appeared.
Yes, sir. PLO.
You are for the petitioner.
Yeah, I'm for the petition.
Who's there?
P. Kataki was appearing earlier of that. And in view of that fact, the earlier interim order was modified in the last day lawsuit, giving liberty to file application for withdrawal of the suit.
Have they withdrawn or not?
Not withdrawn.
We give a further chance day after tomorrow. Okay. Please inform Mr. Kotoki.
Yes.
Those three. As Decker, learned counsel for the petitioner is present, comma. Yes, madam. Where have you disappeared?
Yeah, in court number 20, my lordship.
You have disappeared in court number 20.
Yes, my lordship. Next item there.
Okay.
Yes, sir.
What is your instruction?
In instruction, the honorable court is directed to withdraw the DB petition. I have telephonic information. But
Has it been withdrawn?
I have not received any.
No, we'll have it on Monday next. Get the instructions.
Yes, madam.
Heard three. As Decker, learned counsel for the petitioner. Full stop para. Petitioner who has referred to the order dated 26/4/2024 passed on the earlier occasion by this court. Full stop para. Miss R. Begum, learned counsel for the respondent, prays for and is granted further time of a week to obtain instructions. Full stop para. List on Monday next. Give date.
Apply.
Get the instructions. We
Yes,
want to
ma'am.
finish out these
Yes.
matters.
Applies to me.
Yes.
I did 9.
I can pass over the matter for typing my simple text.
You have filed additional affidavit.
But if I am unaware of the fact,
You have not filed additional affidavit. Oh, I think you have filed or what? No. Oh, yes, filed. অফিস নোট কেউ না থাকে এডিশনাল এফিডেভিট ফাইল করেছে তো আছে নাকি আচ্ছা when day after tomorrow
I should pass over for time being. Please.
you have filed the additional affidavit.
Yes. What if here the petitioner? Yes. Has instituted this suit as a plaintiff, Lordship, for declaration of the agreement dated 25/3/2013, Lordship.
Declaration is what?
Declares for declaration that the agreement and is valid, legal, and binding of the upon the defendant, Lordship.
For
Under
specific
purpose.
specific performance.
Yes, Lord. They have not executed the sale deed, Lordship, after taking an advance of rupees around 15 lakhs. Lord. Around 15 lakhs. Lord.
The sale did not executed.
Not executed.
Then what had happened?
So I filed a suit before the firstly they took the matter before the circle officer, Lordship. A missed case has been filed before it, Lordship.
No, you tell us about the title suit.
Yes, Lordship.
What had happened?
Title suit in the first day injunction was not, I was not granted injunction, Lordship.
What kind of injunction?
Not granted, temporary injunction.
Like what did you pray for in the injunction?
Praying for, Lordship, not to enter into sale or execution on or develop the land till the disposal of the stock.
Then
Lordship, Annexer 5, Lordship, page 45, the order start, Lordship. I was not provided a temporary injunction, Lordship.
Page
from 46, the order start, Lordship.
you had made the advance payment in 2013.
Yes.
And you instituted the suit in 2021.
Yes, Lord. Lordship, since the agreement, Lordship, there was a point, Lordship,
You are challenging that order 11/9/2023.
Yes, Lord. Lordship, at page 23, Lordship, and there was a special clause in white clause 4 in the sale deed, Lordship. Yes. The sale deed was mentioned as one, page 23, para 24. What happened? That herein it is pertinent to mention that the sale.
Now, what is the status of the land?
Status of the land is, it is under a position of the defendant, Lord. One of the defendant.
Possession.
Yes, Lord. Position of the defendant, and he is always avoiding. Always avoiding, and in this regard, the IA lordship, we have tried to file a miscase before the circle officer.
We have to issue notice at this stage.
Yes,
Nothing more than that.
at least injunction may be provided. Lord.
No, we cannot grant expert injunction now at the appellate stage.
Because
We have to
the
at least hear them.
balance of, considering the balance of convenience.
Balance of convenience is not the only criteria. If you have to make out a case for ex parte injunction, it has to be done before the trial court itself.
Yes, sir.
Now much time has passed. Can we pass an ex parte order? We'll hear you, we'll issue notice. Heard Sri S.J. Sharma,
Yes, sir.
Learned Counsel, for the appellant who has preferred this appeal against an order dated 11/9/2023, passed by the learned civil judge, Senior Division, Sibsagar, in Ms. J case number 12 of 2023, connected to title suit number 9 of 2023. Full stop. By the aforesaid order, the prayer for injunction has been rejected. Full stop para. The suit has been instituted for specific performance of a contract in which the petitioner contend that towards execution of a sale deed, comma, an amount of rupees, an amount of about 15 lakhs was paid in advance. Full stop. It is contended that even after receipt of the said amount, comma, the sale deed has not been executed. And in that context, comma, the injunction application was filed. Full stop para. Let notice be issued. Returnable on 28/6. Let's have the registered post with ID. Can you take Dusty?
Yes, it may be taken, but he is avoiding protect the police. He is avoiding the police also.
No, even registered post to be avoided. Dusty, at least you will have an affidavit. We can rely on the affidavit and deem service.
Yes, sir.
Additionally, comma, service by Dusty is also permitted, and such service is to be routed through the registry of this court. Full stop. In the notice accompanying the Dusty, comma, the next date fixed, i.e. 28/6/2024, has to be clearly reflected, and prior to the next date, comma, the petitioner is required to file an affidavit in proof of such justice service.
Obliged.
Yeah, please. So this is against an award of the workman's compensation commission. The operative part will be page 16.
There is a 30 appeal. Section 30 appeal.
Yes, madam.
Where are your substantial grounds?
Substantial questions of law, page 3,
Yes.
The medical certificate that was relied upon issued by public private practitioner. Whether that could be considered as a certificate by qualified medical
What?
practitioner is
The
required.
qualified medical practitioner.
Well, under the Act, there is a authority, under the Director of Joint Health Services, That authority issues nominal certificates are issued under that authority.
No, where is the law that, what is the meaning of a qualified medical practitioner?
My lord, the requirement, lordship will find, the definition is there, page, section.
Section 4(1)(c)(2).
Yes, but qualified medical practitioner means a person registered under any central act, provincial act, or act of legislature of a state, provided for maintenance of register of medical practitioners, and in an area which no such last act mentioned act is enforced. Any person declared by the state government by notice in the official gazette to be a qualified medical practitioner for the purpose of it.
He is registered under the MCI.
No, my lord, the so far as my lord, here, my lord, we have an authority, my lord. And that's another Persons with Disability Act, my lord, there's a authority registered, my lord. That's the Joint Director of Health Service, the issuing the certificate.
This is not a disability report, it's an injury report.
Injury report, my lord, injury report, no, not even injury report, my lordship will might have a kind look at the certificate.
How
copy
much
I
is
have.
the amount?
4 lakhs in odd, my lord.
4 lakhs.
4
What did he
lakhs
do?
and
What did he
14,000.
do?
My lord,
What did he
he
do?
was, my lord, handyman of a truck.
What was the accident? What was the injury?
My lord, injury was, my lord, movement, my lord, it says, my lord, sustained injury is left leg, left hand and on mouth, right, fractured both bone of left leg and was treated primarily at Poswa State Dispensary at the BP Civil Hospital, Nagaon, the private member Spencer. He lost his earning capacity as a handyman of the vehicle. My lord,
Not
and
much. Why are you referring this kind of a bill? That to WC.
my lord,
You know what is the standards now?
my lord.
No, if and WC appeal is absolutely restricted.
My lord, that's Mr. Law, my lord, Mr. Law, my lord.
Where is the certificate?
Well, a certificate I have not annexed, but my lord, certificate copy I have, my lord.
No, where is the discussion on the certificate?
That's my lord, page 16, my lord.
16.
Yes.
Please let us.
My. And there is no assessment of my lord, loss of my lord income.
No,
of all-
that is not your ground. Where is the certificate?
That's also one of ground, my lord. Certificate I have not annexed, my
No,
lord.
no, no. Where is the
Discussion, page 16, my lord.
Say which part?
Issue number 3, my lord.
Is 16 issue number?
3, my lord.
Please 16, not 16.
16, my lord, of the appeal, my lord.
No, no, it's not 16. It's issue page 19.
Sorry, my lord. My lord, issue number 3, my lord, internal page 5. my
Yes,
lord.
yes, yes. Internal is page 19.
Yeah. The claimant stated in his deposition that he had sustained legs on his left leg, left hand and on the mouth, right, fractured both bone of left leg and was treated primarily at Poswa State
Okay,
Dispensary.
okay. We are not entertaining. Third, 3, M. Datta, Learned Counsel for the appellant. Full stop. The instant appeal has been preferred under section 30 of the Employees Compensation Act 1923, within bracket the erstwhile Workmen Compensation Act 1923. Full stop. Please have your seat. The Learned Counsel has referred to the questions of, to the grounds of appeal which have been projected to be substantial questions of law. Full stop. On a perusal of the said grounds, this court considers only the first grounds which may come within the substantial, within the expression substantial question of law. Full stop. The second ground is also analogous to the first ground, and therefore both the grounds are extracted here in below, A and B, page 3, full stop, para. Though the concerned medical certificate has not been annexed, Sri Datta, the Learned Counsel, has drawn the attention of this court to the portion of the impugned judgment and order dated 19/6/2023, passed in case number NEC within bracket WC bracket close 29 of 2014 by the Learned Commissioner, Nagaon. Full stop. It is the issue number 3 is with regard to the injuries sustained and the treatment undergone by the injured, full stop. The claimant, by the claimant, injured now, but the claimant was a handyman in vehicle number AS02E slash 0646 within bracket 407 mini truck, which was duly insured with the appellant, full stop. The effect of the cover by the insurance is not disputed, and the dispute is only with regard to the medical certificate issued, comma, more specifically with the requirement that the same has to be issued by a qualified medical practitioner, full stop. Para. Section 4(1)(c)(2) of the Act reads as follows, full stop. Para. The discussions in issue number 3 of the impugned judgment does not even give an indication that the aforesaid requirement is not fulfilled by the certificate issued by one Dr. D.N. Hazarika, who is employed with the BP Civil Hospital, Nagaon, and also has a private chamber, full stop. The said Dr. D.N. Hazarika was also examined as PW2 within bracket medical witness, full stop. Para. On a perusal and consideration of the aforesaid discussion, comma, this court is of the opinion that the requirement of being a qualified medical practitioner as required under section 4(1)(c)(2) of the Act is substantially met, full stop. In any case, comma, an appeal under section 3 of the Act is a restricted appeal which is available only on substantial grounds of law, substantial questions of law, and the questions tried to be raised would not come within the restricted meaning of substantial question of law, full stop. Accordingly, the appeal is held to be not maintainable and accordingly dismissed, full stop. Like upar mein likha. This court has also taken into consideration that the amount granted by the award is rupees so and so, and taking into consideration the nature of the injuries, comma, the said amount is not held to be excessive in any manner.
This case may also be disposed of, madam.
Miss case, in view of the, I
Apply the lord.
As per objection dated 31st/5/2024, Lordship. Service report upon respondent number 14428, Lord, sorry, avoid.
Petitioner dated
acceptance of notice on behalf of 2 and 3 placed on records. 1/4. When was it issued? 21/5. Oh, okay, 21/6. Why is it listed today? 24/5. I think it is. That service of notice is complete. Why? Gogoi? Last order says that the
Service is complete.
But
But
office note
official-
says something else. 31/5.
Yes.
I think there was some, maybe due to inadvertence.
Yes.
We'll wait for the service. We'll have it after 3 weeks. Okay.
Yes.
Interim order may be continued.
Okay. It appears that the observation of this court in its order dated 24/5/2024 regarding completion of service was inadvertently made. Full stop. In fact, inadvertently made in view of the office notes dated, etc., 21/5/2024, and also, no, 2024, full stop. Further, the subsequent office note dated 31/5/2024
Yes.
reflects that while notice on respond numbers 2 and 3 are complete, those for respond numbers 1, 4, TO28 are not complete. Full stop, para. In view of the above, list of the 3 weeks for fresh service report upon the respond numbers 1 and 4 TO28. Full stop, para. Interim order passed early. To continue till the next date of listing.
Item 12.
Maybe this is your lordship. This appeal lordship we have filed. First lordship, as per the amended act, and even before that, there is no provision for pay and recovery. And already the learned member came to a conclusion that there was violation of policy condition, and then passed the order that the insurance company will be entitled to realize the amount. Lordship, Apex Court as well as our High Court held that the pay and recovery can be given only by the Apex Court when under Article 142, not otherwise. So main ground.
Was pay and recovery ordered in exercise of 142?
No, the tribunal doesn't have that.
No. In those cases.
In those cases, yes. In this judgment, lordship, we will appeal this one. Justice Bopanna passed, and then they said this.
No, earlier judgment, the initial judgments. Pay and recovery.
Initial judgments, yes. Because in our High Court judgments, those are discussed also, that the pay and recovery is to be given by. So the notice may go, and if lordship.
No, but what will happen to the fate of the claimant? In a tussle between me and the owner, should the injured be should suffer?
But lordship, if by the new act, earlier there was a provision that pay and recovery is that, but after the amendment, that has been totally removed. Lordship.
No, this is an accident before the amendment.
Yes, that is true. So lordship, it will need some deliberation, lordship,
But why
but we
should
can
they-
deposit 50% and let them appear, then they file a petition for withdrawal, lordship.
No, we are only interested in the fate of the.
I understand.
See, you may have a good legal point, but that will ultimately affect the person who is injured. Is it an injury case or death case?
That's it.
Death case, see?
So we can deposit, let them come, and then if they file, then.
The owner is a respondent.
Yes, is the respondent.
Okay.
He's-
I is for,
For stay, lordship.
okay.
I number 161.
Third, Ms. R.D. Mazumdar, Learned Counsel, for the appellant who has referred this appeal under section 173
Yes, sir.
of the Motor Vehicles Act 1988 against a judgment dated 28/2/2024 passed by the learned MACT number 1 Kamrup M in MAC case number 1404 of 2017, full stop, by the said judgment, an amount of rupees 14,
14,95,200.
95, 200 along with interest has been granted, has been awarded in a death case. Full stop para. The grounds of appeal have been structured that the liability should be settled, should have been settled, not on the insurance company, but on the owner of the vehicle, inasmuch as there were findings regarding violation of the policy conditions. Full stop.
And also on quantum law, because he was a bachelor,
Okay.
the calculation ought to have been.
Further grounds have been raised on the quantum of the amount. Full stop. It is also contended that the tribunal would not have the jurisdiction and power to make an observation regarding pay and recovery, which was exercised by the Honorable Supreme Court in terms of Article 142 of the Constitution of India. Full stop para. Admit, call for the records. Let notice upon the respondents be issued by usual course as well as by registered post with AD. Steps within 3 days. Full stop. In the IAU, right? By the present application, comma, the applicant / appellant has prayed for stay of the judgment and award dated so and so passed by so and so in MSC so and so. हाँ ऊपर जो लिखा था वहां से ले लेंगे. First of the connected appeal has been admitted today and records have been called for. Full stop para. Considering the facts and circumstances and also that the award has been passed in a death case, comma, the impugned judgment and award dated so and so is stayed subject to the condition that the appellant deposits 50% of the awarded amount before the registry of this court. Full stop. Such deposit be made within a period of 6 weeks from today. Full stop. The opposite parties may make necessary application for withdrawal, which should be duly considered in accordance with law.
Highly obliged, Your Lord.
You can take this back, madam. I must meet this.
Item 13.
I dispose of. Mr. Bhatto, what is this?
In this case, appeal petition, this was the representative of Assam government.
Of Assam?
Of Assam law.
Achha, okay.
And in this case, there was no loss of earning as per the CFT scheme law. So Lordship, appeal may be in this case, there is no loss of earning.
How much is the amount?
The awarded amount is Lordship.
$53. Okay.
59,724.
You deposit 50%.
Lordship, in other cases, we are depositing 20%.
20% in MSC cases.
Lordship, in this case, Lordship, only they will get the 57%. Lordship, there is a decision of our High Court also. Lordship. The Supreme Court also Lordship in favor of us.
No, we'll not go for 20%. Money decree. We may go for 100%.
Then
Sorry, we'll not follow.
Then notice maybe
Civil decree, you have to deposit 100%.
Then notice maybe issued regarding the scale.
Okay, we'll issue notice, but no stay. What is this? You get back the amount after you succeed in the appeal. We grant 50% only because of the practical reasons. Otherwise, you are required to deposit 100% money decree. Until you deposit, we will not entertain an appeal. Show us the provision of law in a money decree. What is the procedure to be adopted by an appellate court?
Okay, at this case, notice maybe.
If you are not insisting on a stay, we'll issue notice. That is okay. But if you're insisting 50%, that is the minimum we'll give. Heard Sri K.K. Bhatta, learned counsel for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act 1988 in respect of a judgment dated 7/3/2024 passed by the learned MACT 1 Kamrup M in MSC case number 1951/2019, by which an award of rupees 53,59,722 with interest has been awarded. Full stop. Para. Admit, call for the records. Para. Admit, para, call for the records. No, para. Let steps be taken for service of notice upon the respondents by registered post as well as by usual process. Steps within 3 days. Para. In the IU, right? This is an application for stay of the judgment and award dated so and so, passed by so and so. Full stop. Let notice be issued, returnable by 4 weeks. Steps, same. Steps within 3 days. Take by registered post as well as usual process. Okay.
Item 14. May I please, your lordship? Lord, this appeal is directed against the impugned judgment, my lord, and award passed by the learned tribunal dated 6/3/2024.
Here for enhancement.
My lord, I am for, my lord, I am, my lord, the pro forma defendant, opposite parties, that is father and mother of the deceased, my lord, who, my lord, died in accident. The claimants, my lord, were the wife, 2 daughters and son. And, my lord, the opposite parties were, my lord, driver, owner and
Now, what is the appeal? What is the appeal about?
appeal is against, my lord, the we pray for modification of the award judgment, my lord. My lord, stating inter alia, my lord, that the quantum of award that has been awarded to the mother, my lord, saying that she is dependent on the deceased, my lord, that only 9 lakhs, my lord, has been awarded to the mother. That is the appellant here before your lordship, but no interest, my lord, has been awarded against that particular, my lord, the company award. But the claimant number 1, 2, 3, and 4, my lord, they have been awarded the interest, my lord, at the rate of 18%. So interest part we have not been given, my lord. This is number 1. Number 2, my lord, the appellant number 2, who is the father, aged about now 90 years. The learned my lord, trial court, my lord, has observed that the father is not dependent on the deceased. This is absolutely, my lord, in my respectful submission, is not correct, my lord.
Was there evidence adduced
There is evidence, my
on the
lord. There-
dependency aspect?
My lord, your lordship, kindly see the cross-examination part, my lord, at page 59.
Yes, you are from whom?
I am for the claimant, sir. Widow, 2 daughters, sir.
They have no objection, perhaps, my lord, if we.
No, so mother's interest is a one ground. We may consider. What is the father's claim now?
Father's, my lord, he has not been awarded anything.
Now, if he is awarded anything, then it would have to come for it's a question of apportionment of the entire amount. Amount cannot be enhanced. It will be the same amount. Some portion of their part the father will get if you succeed.
That's true, my lord, but my lord, if he is not given anything.
What is the age of the father?
90, my lord.
90. What did you do?
My lord, I did not do anything, but I absolutely dependent, my lord, on
No,
my.
all your lifetime you were dependent even before the birth of your son.
During my young age, my lord, I used to do something, but now
What
I
something?
was a cultivator, in fact. I was,
Son was doing what?
my lord, this cultivation of my page.
Son was also a cultivator.
Yes, my lord, all are cultivated.
No, this was the government. Deceased was the government, sir.
So deceased was service holder, my lord, sorry. Deceased was, my lord, he was a government.
Now you try to modify that he was cultivator as well as a government
No,
servant.
no, my lord. No, no. Well,
It
I
serves the
thought,
purpose.
my lord,
A government servant can also be a cultivator. Off time he cultivates.
that may be.
Dr. Kindly,
We thought that would be your answer.
Dr. Kindly to the page 51. That place.
Okay, let us admit this. But we don't think we'll get anything in finally. Interest part, of course, we'll consider, but
My lord,
Appellant has three sons.
my lord.
appellants are Hindus or Muslims?
Lordship, appellant has three sons.
Okay, father may have a claim, okay.
Appellant has
My
three
lord,
sons. Lordship.
kindly have a
Three
look.
sons,
my lord,
okay.
page
Three sons. One of the deceased, another two remains.
Okay.
They have no
they are-
source of income, my lord, except in their cultivation.
the brothers of the deceased, what did they do?
They are cultivated.
Cultivators.
Yes, they have no source of income, my lord. In fact,
They are having.
Why do you need money at 90?
for my survival, my lord. for my
Survival,
mainten-
they are
for
not
my
supporting
maintenance.
you.
My lord,
Wife of got 9 lakhs, she gives nothing to you.
my lord, she will, definitely she will give, my lord. But
No, 90
if I am
years-
entitled, my lord, as per law,
Now 90
Madam,
years, what do you do?
I won't do
Ultimately, you have
anything, my
to-
lord. What I am saying,
You
my
have to
lord,
take from the widow and your grandchildren.
my lord,
Will
they
will
they
that be
are-
proper?
They are not looking after me. That is the problem. Except my
You-
wife, my lord.
You don't love your grandchildren.
I am my lord. I am my lord. I love my lord.
So if you love, why do you want an extract
What?
from their portion?
Because, my lord, they are, my lord, not looking after me, my lord. I have to maintain myself, my lord. Of course, my wife is helping me, my lord. She will provide her share of, my lord, the compensation to some extent to me.
You have increased your age within 3-4 days. You had written 87 years. Your filed is when? Your age increases by
No, my lord, I am told, my lord, maybe it is 87, my lord. I am told, my
from
lord, that-
17th May till today, you have increased by 3 years.
No, 87 years.
87.
87. However, my lord, he is elderly person. That is, my lord, that is a fact.
You stick
Now, my lord,
stick to the claim of the first appellant. You take instructions, give advice to your client number 2. Okay, heard.
My
Speak,
lord,
case
your
and let it
lordship,
counsel.
kindly have a look, my lord. It is admitted, my lord. They
let-
have admitted that I am
Let us counsel,
dependent.
yes, let us learn counsel for the appellant who has referred this appellants, referred this appeal under section 173 of the Motor Vehicle Act, so and so against so and so, as select DG. Admit. Call for the records. This is item number. Mr. Sarkar, you are for whom?
For the claimants.
1, 2, 3, and 4.
Yes.
380 Sarkar Learned Council. Has entered appearance for respondent numbers 1, 2, 3, and 4 within bracket claimants.
Yeah.
And accepts notice. Full stop. Let extra copy of the memo of appeal along with enclosures be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent number 5 by registered post with AD as well as by usual post. Mr. Sen, who is the respondent number 5?
5 is the, my lord, Bajaj Alliance.
Is it Bajaj Alliance?
Yes.
Read who is the respondent number 5. What is this? You are a seasoned counsel. What is legal manager?
Branch manager, it should have been branch.
Branch manager also. Is branch manager the legal entity? From where do you get this? You don't make the entity a party. We have checked sometimes in the claim, they have a wrong arraying of parties. That also you have not followed.
I'm sorry, my lord, it was written in the complaint petition.
No, no, not written. See the judgment.
No, my lord, page
See the
41.
judgment. See
Page 41.
see the judgment. We'll go by the judgment. First page. Third is Message Brothers Alliance. Okay, yeah, steps within 3 days. Okay.
Messrs. Bajaj Alliance, but we followed, my lord, the page 41. That is the difficulty, my lord. Yes, my
You have
lord.
a caveat also. Heard 380 Sarkar caveat, huh? Learned counsel for the caveators who have lost this caveat in connection with judgment and award that is so and so passed by so and so so and so. The caveator would be heard in the event this court proposes to pass any interim order. Caveat stands disposed. Okay, next steps.
My lord. Oblige me.
16.
May I please your lordship? This is an appeal against the impugned judgment and decree dated 7/5/2024.
Second appeal.
Yes, your lord. Passed by the learned additional district judge, Hailakandi district, in title appeal 3 of 2016. In dismissing the appeal and thereby affirming the impugned judgment and decree dated.
You are whom?
I am appeal and defendant number 2, your lord.
You are defendant number 2.
Yes, your lord.
Suit was for?
Suit was actually, the pair person is page number 62, lord. The at of the page.
Suit for?
It was for declaration that defendant number 2 and 3 do not have any right title interest over the property that has been acquired by the government for construction of a bypass road under NH 154. NH 154. Your
It was more of an injunction suit, not for declaration of for the plaintiff,
lordship.
not for declaration in your favor.
No, lord.
More
Actually,
for-
what happened in this case, your lordship, government in land measuring a portion of land measuring 1
It's more of
bigham.
an injunction suit. How do you pray for a declaration that somebody does not have any right?
I am not the plaintiff, your- and the defendant number 2, your.
Oh, you are the said defendants. Okay,
Yes,
okay. The suit was for a declaration that you do not have any right.
Yes, that was the suit, your
Okay,
lordship.
then what had happened?
And while the government has acquired the land,
Suit had decreed.
the suit has been decreed, appeal has also been decreed. But our grievance is that issue number 2 regarding maintainability of the suit, that was the finding of both the court was perverse, your lordship, because in this suit, the substantial questions of law that has been framed is at page number 7, your lordship may kindly peruse, your lordship. It was not as per mandate of section 79. State of Assam has not been made party, your lordship. And Union of India, because the National Highway Authority, although DC is the appropriate authority, lordship, these 2 entities were not made parties, your lordship. Moreover, regarding the maintainability of the suit,
Your maintainability is on the non-joinder,
no, lordship.
not on non-joinder.
It has, as per section 9, where the civil court can take cognizance of all the suit, except there is an implied or express bar. So in this case, lordship, as it is an acquisition matter, a land acquisition, so section 18 is a bar. Because the plaintiffs were aggrieved by the apportionment of the money. That has been, because 91,000 has been paid to us based on our possession. Being aggrieved, they did not approach the appropriate authority. If your lordship kindly peruse section 18 of the 1984 Act,
Where is the ground that suit was not maintainable? There is a bar
lordship,
in your written statement.
lordship.
In your written statement.
In my written statement, lordship, we have stated that at the time of survey, we being the persons who were in possession, and that the deputy commissioner rightly decided, and we
Now,
have.
where is the, if you're right, if you're trying to take recourse to the provision of the Land Acquisition Act, a bar of a civil court. Where is that, that defense?
Lordship, in that case, your lordship,
You
court has
cannot just
framed-
take up a defense in a second appeal.
No, lordship, we are not, court has framed 5 or 6 issues. We are agreed that issue number 2 was not properly discussed, your lordship.
Let us see issue number 2. Issue number 2, yes, please.
Issue number 2. Page 15, your lordship, of the appeal. As regard the maintainability, issue number 2, plaintiff instituted the suit for declaration.
Page 15.
Yes, 15, your lordship.
Hmm.
Plaintiff and defendant number 1.
Which issue?
Issue number 2, your lordship may kindly peruse from page
Okay.
13 onwards.
Page 14, whether the suit is maintainable.
Yes, your lordship. Plaintiff and defendant number 1 are the legal heirs of late so-and-so and entitled to get compensation money.
Now let us see your written statement. What was your contention towards maintainability? Where is the WS? Six zero. 68. Your defend number 2.
Yes, your lordship.
65 it starts. Yes.
The suit is not maintainable in its present form and manner. That has been a para 2.
No.
That the
that-
suit has been filed by the person.
You have not stated nothing regarding maintainability. Did you adduce any evidence?
Lordship, at the appeal stage, we have additional evidence we have.
Only at the appellate stage?
Yes. Additional evidence we have adduced.
Order
to the
41
lordship.
rule 27.
Witnesses were also examined.
41 27.
Lordship, yes, your lordship.
In the first appellate stage?
Yes, your lordship.
What was the evidence?
Evidence, but the appellate court did not discuss anything regarding that.
Let us see your evidence.
We have not annexed in the appeal, your lordship.
Why?
Actually,
That-
plain
That is
written,
what we will seek for.
then I may be allowed to file an additional affidavit.
Bring those into, if you want something to be done by this court. Second appeal, you know our restrictions.
Then I may be allowed to file an additional.
File additional evidence.
Yes.
AC to DD. The primary ground projected in this second appeal as substantial ground is on the aspect of maintainability of the suit. Full stop. This court has perused the pleaded stand of the appellant who was defendant number 2 in the suit, from which nothing can be discernible on any specific pleadings on that issue. Full stop. Para, on a specific query, comma, the learned counsel, Ms. Dasgupta,
Yep.
has, however, submitted that in the first appellate stage, comma, application under Order 41 Rule 27 was filed for adducing evidence, which however is not annexed with this memo of appeal, full stop, para. On a prayer made, the learned counsel is granted 2 weeks' time to bring such evidence on record by way of an additional affidavit.
My problem.
Ideal 17, along with ideal 62.
Wait, please, Lord. So in this case, I filed petition for substitution, setting aside and toleration of delay, Lord. Notice the going out of control of it.
Why is 64 is connected? That is the
Lord,
main case.
Yes, Lord, because I had done in item number 64, which was defective, then later it was checked.
Three, 4, 180 days in filing the substitution.
Yes, Lord.
And you have setting aside abatement also.
Yes.
Notice will go where? In which?
Nolbari, Lord.
No.
No.
In which case?
In the condolation petition, Lord.
Unless we set aside the abatement, can we consider the substitution, the delay condemnation?
Okay.
See, these are different connotations.
Yes.
A person in a suit, he expires. There is a period for his substitution. You do not substitute. The Act prescribes extension of the limitation. Thereafter, you do not do, the matter gets abated. First, so till the matter is abated, the legal heir still has a right to be inserted.
Yes.
Now the abatement has to be set aside. Then we'll consider your.
That petition is not numbered.
Okay, we'll issue notice at this in this petition. Heard Sri R. Sharma, learned counsel for the applicant applicants who by means of this application has prayed for condonation of delay in filing the substitution petition, full stop. This court has perused, this court has noticed that that the appeal has also been abated in the meantime. And an application for setting aside abatement has also been filed. Full stop, para. Let notice be issued, returnable by 4 weeks. Has anyone appeared?
No, Lord.
Earlier case?
No. Notice was served in the main appeal.
Let steps be taken for service of notice upon the sole opposite party by usual process as well as by registered post with AD. Steps within 3 days. What is 1636? 1636 is numbered. All are numbered.
All are numbered. Actually, it is not. Otherwise, that. So in all the rest is actual. Step.
You pass this order, write this order 1638, huh? Section 5 water refill. Okay.
Oblige.
Yes.
May I please, your lordship. Lordship, as per instructions from my senior, we have tried to communicate with the client petitioners since the last 5 years, but he had not reverted back to us. In such circumstances, we may be allowed to withdraw from the state.
This CRP, this IA, along with the connected CRP was filed in the year 2016. Full stop. The impugned order is dated 10/2/2016, passed by the learned additional district and session judge Nagaon in Miss within bracket P case number 176 of 2012, whereby the petition for revocation of the probate was dismissed. Full stop. Para. Notice in this application filed under section 5 of the Limitation Act for condonation of delay of 113 days was issued on 28/9/2016. Are you appearing?
Yes, I am appearing on behalf of respondent number 1 and 2.
What is your stand?
Today I have filed affidavit, objection.
Where you will be filing? But there is none to press this application. What is the present status?
Service is not complete.
No, what is the present status of the probate case? Will was probated, thereafter what has happened? Para, কি লিখিল লাস্টটো? What's the para? Sri, you are what day?
Cost of bid.
B day.
Cost of bid.
Sri B day, learned counsel, appearing on instruction of Sri PC day, learned counsel, however submits that the clients are not in touch for a period of over 5
Yes.
years, and therefore the learned counsel would not like to continue. What's the para? Miss So-and-so, learned counsel, has appeared for the respond numbers
1 and 2.
1 and 2. Full stop. Para. In the interest of justice, matter is adjourned to be listed on Monday next to give a further opportunity to the petitioner to be represented. Full stop. In the event that there is no representation, comma, this court would pass appropriate orders.
Right.
May I please?
Yes, please.
In this paper, two eyes, your fellow. One is for substitution, another is for setting aside abatement, my lord. Condonation has been allowed, my lord.
Delay has
Notice-
been
notice-
condoned.
Yes, sir.
Delay has been condoned.
Yes, my.
In the setting aside abatement, what has happened? The abatement
My
has been
lord,
set
no.
aside.
No. No, not yet. Notice has been served, my lord. Oh, page note, my lord, 27/5.
Okay. Okay. Third, Dr. P.K. Goswami, learned counsel for the applicants who has filed this application under Order 22, Rule 9
Yes, my lord.
of the CPC for setting aside abatement. Post the para. Vide an order dated 8/11/2021, comma. Notice was issued. Post the para. Order, office note dated 27/5/2024 reflects that notices have been duly served. Full stop. Para. As the application for setting aside abatement is not contested, and considering the grounds, comma, the instant application is allowed, and the order of abatement dated what is the order? Was there any order passed?
No, there is no order, my lord.
And the aspect of set and the prayer for setting aside abatement is allowed. Full stop. I accordingly stands disposed of. The IA for substitution has been numbered.
617, my lord.
Okay.
No.
No, 717.
7-1.
That IA has in 160, huh? Then you write in 717. The prayer for setting aside abatement made in IA 718 of 2017 has been allowed today. Full stop. Para. By the present application, comma, application filed under Order 22, Rule 3 of the CPC, comma, the applicants have prayed for substitution of the
Applicants number 1 to 24, my lord.
applicants number 1 to 24 have prayed for the substitution on the death of
Mohammed Akhil Ali,
of the original
revision petition.
petitioner Muhammad Akhil Ali. Full stop. The said respondents the applicants in paragraph 8 of this application has given their details. Out of which from serial numbers 1 to 20,
4, my lord.
no, 1 to 20 claim to be the sons of Akhil Ali, and from serial numbers 21 to 24 claim to be the wives of Akhil Ali. We have 20 sons.
My lord. 4 wives. my
4
lord.
wives. God's grace that he has passed away. Otherwise, there would have been more, I think. What was the age of at the time of passing away?
Near about 80, my lord.
The entire village is yours or what? It seems so.
Yes, sir.
Para, considering the above, comma, the instant application for substitution is allowed, and the applicants are substituted in place of the original petitioner, Akhil Ali, as petitioner numbers 1A to 1, 1X hobo niki 24 hobo na 1X 24 numbers. Full stop. The learned counsel for the applicants to I accordingly stands allowed, huh? In the main CRPU, right? The
My lord, in fact, main CRP, my lord, notice has not been served, my lord, yet.
first you first you give an amended cost title.
Yes.
Okay. Wide orders passed today, comma, both DIA 718 of 2017 for setting aside abatement and IA 717 2017 for substitution have been allowed, full stop. Para, learned counsel for the petitioner is accordingly required to file amended cause title incorporating the names of the substituted petitioner as petitioner numbers 1A to 1X. Full stop. Such amended cause title be filed within a period of a week from today. Only typing and fighting. What is there?
Yes.
2-3 pages. 28. 20.
So this is an application for continuation of delay of 18 days in preparing the connected appeal. Our
Lordship, they were last projected to take state.
Alert,
It's
where-
been more than 1 year. They have not taken state on the respondent on the opposite party number 2. Lordship may also kindly.
You are for
I'm for the opposite party number 1.
1. Okay.
it is not correct. While he submitted that I have not taken step, I have taken steps and later on it was not effected. So this honorable court directed us to take Dasti service. So we tried to take the Dasti service, but nobody came from Lakhimpur. So in the meantime, I have observed that one of the respondent number 2's address, the name of the father is wrongly typed.
Hmm.
So if I may be allowed to correct this false title, perhaps one
You
of the-
file an application?
yes,
Or
we may be allowed to file a fresh memo in before the registry or
no,
correcting
without
the
an,
address.
without an order of this court, how can you file? File an IA for correction will allow, file fresh memo. Okay. So we as discussed, learned counsel for the petitioner. No, don't write like this. No, take it. Learned counsel for the applicants submits that with regard to the issue of steps upon the respondent number, opposite party number 2, comma,
Yeah.
the steps by Dusty service, by Dusty could not be taken due to unavoidable circumstances, full stop. It is also submitted that while describing the opposite party number 2, comma, there is some mistake with the name of the father of the said opposite party number 2, full stop. The learned counsel accordingly prays for and is granted liberty to file appropriate application for correction of the name of the father of the opposite party number 2. Full stop. List after 3 weeks.
Yes.
Okay.
21.
See, in this case, I have to take instruction whether you want to withdraw the petition or not.
Old appeal, review petition. Review petition for what?
Because there is no legal error in this case. But the appeal was dismissed of it. The court directed to make the legal error as a party lawsuit. They could not produce it. The name of the legal error. There is no legal error. In spite of our best effort lawsuit, we could not collect the name of the legal error.
We'll have it on Friday, take instructions. Withdraw the appeal then.
But the appeal was dismissed. Thereafter, review petition was filed.
No, withdraw this application.
But I have to take instruction on
Friday.
Friday. Next week.
Monday.
Next.
On the prayer of Sri K.K. Bhatta, learned counsel for the applicant. Matter is adjourned. From 18, don't write like this. Sri K.K. Bhatta, learned counsel for the applicant. Prays for an adjournment to seek instructions. Full stop. Para. It is submitted that. No, para. Don't write like this. Considering that this review is pending for the last about 6 years, comma, slight accommodation is granted, directing listing of this matter on Monday next.
22.
Please, earlier I want to withdraw the instant suit revision application, but later on the party has instructed not to withdraw the same as we want to proceed. So I will be allowed to take fresh steps upon that.
From 18 it is pending. What is the revision about?
Madam, the revision is about that the petitioner here is the plaintiff filed a money suit for realization of money. But the promissory note, it was executed between the parties that was could not be executed during the suit. So the suit was dismissed. Thereafter, we filed the appeal against the state judgment in order, and the appeal was thereafter we filed a promissory note and we filed an application to adduce additional evidence, which was rejected, Madam. And against this rejection, we filed this division.
Your application under 4127 was rejected
Madam.
to adduce additional evidence at the appellate stage.
Madam.
What is the ground?
The grounds of page number
Page number?
five,
5 of the
application. Minute.
5, yes.
Learned appellate court has failed to pass an appropriate order in money appeal, because in an appeal, while the appellant has filed the petition under order 41/27, the appellate court cannot decide the state petitioner. It is the obligation of the appellate court that the petition under order 41 rule 27 of the CPC must be decided along with the appeal. If the appellant
Let us see the order.
42.
Page 40.
40.
Yes.
Page number 43 is the last paragraph. It is research.
Now, where are grounds for not producing the main document at the stage of the suit?
Please.
Let us see your application of 4127. What did you state?
Petition was not next year.
Simply filing an application will not do. You have to meet the requirements. In spite of due diligence, you could not produce the document or could not deduce the evidence. And the order passed by the learned court appears to be in consonance with the law. Court has very elaborately narrated the provisions of 4127. What are the conditions? That notwithstanding the exercise of due diligence, it was not within your knowledge. Your entire suit was based on the promissory note. What is there to be contested here? No point. No point having these kind of matters pending, to be kept pending. We dismiss this revision. Heard. Your AC Roy, what is your
No,
name?
I am M. Sahu on behalf of Financial.
Your name?
M. Sahu on behalf
M.
of.
Sahu.
appearing on behalf
Heard Ms. M. Sahu, learned counsel for the petitioner, who has preferred this revision petition against an order dated 4/7/2018 passed by the learned civil judge Kamrup in money appeal number 1 of 2015. Full stop. Please have your seat. By the aforesaid impugned order, comma, the application filed by the present petitioner under order 47 for under 41 rule 27 CPC has been rejected. Full stop. Notice was issued. Notice was issued by this court on 30/11/2018. Full stop. The subsequent order dated 15/11/2019 of this court would reflect that the petitioner was granted time to take fresh steps on the sole respondent, and thereafter, and the further office notes would reflect that service is not complete. Full stop. Para. The order dated 30/5/2024 of the the order dated 29/5/2024 of the learned Lozima court would reflect that the learned council had made a submission that they would not like to proceed with the instant petition, and in terms thereof, comma, an office note was made on 30/5/2024, whereafter this matter has been listed today. Full stop. Para. Ms. Sahu, the learned counsel for the petitioner has however submitted that in spite of the aforesaid submission, comma, the petitioner would like to proceed with this petition. Full stop. Para. The impugned order dated 4/7/2018 is in connection with an application filed by the present petitioner under order 41 rule 27 of the CPC. Full stop. The said application, however, has not been annexed with the present provisions. Petition. Full stop. Para. Be that as it may, comma, this court has carefully examined the said order dated 4/7/2018. Full stop. The learned civil judge Kamrup, after discussing the provisions of law laid down in order 41 rule 27 CPC, has come to a finding that the plaintiff did not exhibit the concerned document, which is an agreement dated 3/9/2010 pertaining to money transaction, which was the foundation of the claim made in the money suit. Full stop. Para. No. The learned court has also submitted that the learned court has also observed that the conditions attached to an application under order 41 rule 27, namely not being able to produce a document in spite of exercise of due diligence has not been fulfilled, full stop, para. The aforesaid provision of Order 47, Order 41, Rule 27 is an exceptional provision in the CPC to adduce production of additional evidence in the appellate court, and the entire objective is to maintain fairness and ensure that interest of justice is served, full stop. In the instant case, comma, the preconditions attached to the aforesaid provision of law do not appear to have been fulfilled by the petitioner, full stop. Para. Further, comma, the powers to be exercised by this court under Article 227 of the Constitution of India, under which this petition has been presented, is a supervisory power with the objective to ensure that the subordinate courts do not exceed their jurisdiction, full stop. The impugned order dated 4/7/2018, on the other hand, appears to be a reasoned order wherein proper grounds have been cited for rejecting the application, full stop, para. In view of the above, comma, this court is of the considered opinion that the present is not a fit case wherein any relief can be granted to the petitioner, full stop. Petition accordingly stands dismissed.
Object.
None appears for the petitioner and for the applicant on call, full stop. On the last occasion, that is 13/5/2024, a similar situation had existed, full stop. Para. For ready reference, the order passed on 13/5/2024 is extracted here and below, full stop. Para. In view of the observations made above, and made above, the observations made in the last order, comma, the instant application is accordingly dismissed for non-prosecution. Logo to কি? In view of the in view of the it is made clear that in view of the order passed of rejecting this application filed under Section 5 of the Limitation Act 1963, comma, the connected appeal also stands rejected.
24.
May I please allow? Look, here in this particular appellant are all dealing person in filing this second appeal. There is some delay. There is 246 delay. Thereafter, notice was issued, and response number 2 already appeared, and said that the response number 1 already died. Thereafter, we filed the substitution petition. But in filing the substitution petition, there is some delay. Therefore, we filed the abatement petition along with condonation of delay in abatement.
Here for whom?
All the respondent.
Okay, you have filed your objection.
No, Lordship, here is two delay petition. One for Lordship main case, another for Lordship.
No, main case has gone for, has been abated. Now they are
Yes,
filing an application for setting aside
yes,
abatement.
we have to
In
file.
which,
subsequent.
in which there is also delay, so they are also prayed for condemnation of delay in considering the application for setting aside abatement.
Yes,
Will you file objection or have you filed?
yes, we have to file Lordship, Lordship, we.
Okay. Oh. On the prayer made on behalf of the
After 3 weeks,
opposite
after
party.
vacation,
What vacation? Which winter vacation? Or Bihu vacation?
after 3 weeks.
On a prayer made on behalf of the respondents,
From
common
1 July,
3 weeks time
maybe
is
vacation.
granted to file objection application.
Yes.
Objection affidavit.
Always.
Obli-
25.
So that taken for consideration or delay in preparing an appeal against the decree for divorce passed by the Tinsukia Court, Milan,
District Court.
Tinsukia District Court. My main submission regarding maintainability of the appeal of the decree by the
Suit.
suit by the Tinsukia Court, Milan is without any jurisdiction because that is not under the provisions of the India. He could not prefer that appeal, Milan, the application before the court.
Why?
19 under section 19 of the Hindu Marriage Act.
Of the?
Hindu Marriage Act, Milan.
What is the bar?
19.
Bar means, Milan,
Jurisdiction.
that has to be within the local limits of whose ordinary general jurisdiction is where the marriage solemnity or respondents at the time of presentation of the petition resides.
Did
or
you contest the suit?
They contested the suit, Milan. They engaged one counsel from Bihar. They are staying permanently. Then on the subsequent days, they could not come. And later on, they came to know that decree has already been passed. And against that decree, I have filed this appeal, Milan. And for condemnation of this appeal.
How many days delay?
144 days.
Yes, what do you say?
Your Lordship, actually, I am appearing on behalf of the respondent advocate.
Yes.
Your Honor, your Lordship, may kindly allow to time.
You have not filed objection. You filed your objection?
On
Let
last
them-
occasion also, they have filed. They took
Time
time.
may be granted, your Lord.
Okay, we'll the last opportunity. You file it. The matter is of 2019.
Yes, Milan. We took all these years, Milan, for service of notice upon him, Milan.
Heard Sri D.P. Chalia, learned senior counsel for the applicant who has filed this application under section 5 of the Limitation Act 1963 for condemnation of delay of
44 days, Milan.
144 days. Full stop. Para, your name?
S.
S.
Saikia.
Saikia.
Yes.
Sri S. Saikia, learned counsel, has appeared for the sole respondent, sole opposite party, and has paid for further time to file objection affidavit. Full stop. Para. In view that on the earlier occasion dated 26/2/2024, time was already granted to the sole opposite party, as a last opportunity. Further 2 weeks time is granted to file objection affidavit. List after 2 weeks.
Much of it.
26 and 27.
Sorry. This appeal is also against the judgment for enhancement losses and a compensation lawsuit regarding land acquired by the respondent authority.
IA for?
IA lawsuit actually, this IA was filed by some other advocate lawsuit initially. I have appeared subsequently lawsuit on that. The IA perhaps is not maintainable, not necessary because there is no delay is also not there. So
IA was for delay condemnation.
that's it. I have gone to the IA same.
No, IA was for delay condemnation otherwise.
Yes, leave, seeking leave. Leave is also in.
Leave for?
We file this appeal. Perhaps is not necessary as per section 54.
You are, who are you?
I am the appellant.
No, no, appellant we know, but
I
who
am the
are?
lawsuit. Palaban Tea Limited is a company lawsuit whose land was acquired by the government authority, ONGC.
You are the beneficiary.
Yes.
Land has been acquired for you.
My land has been acquired by the ONGC.
Oh, you are the affected party.
The affected party,
Okay, then your land has been acquired by the,
ONGC.
okay, then
Then lawsuit, we have prepared an objection stating that the amount of compensation provided by the lawsuit authority is not sufficient. So accordingly, lawsuit, land acquisition process was there.
no, did you have a, was there a reference under 18?
Yes.
Reference was there.
Reference was there.
Then
lawsuit, the reference order was also passed. That is supposed to have an.
what has happened?
Reference order lawsuit, they have also calculated wrong calculation lawsuit.
You are not satisfied with the
Yes.
reference. Okay, you wanted enhancement.
Enhanced.
So you have come for 54, under 54
Yes.
of the earlier act.
Clause.
Okay. Yes,
Yes, Lordship, it was,
appeal has been admitted or not?
Lawsuit initially, many times this case was listed, but none appears. So it was initially dismissed for default. So I have filed restoration,
Two
accordingly, that restoration is allowed.
Restore has been allowed, but appeal is yet to be admitted.
Yes.
We'll admit this appeal.
amount is very huge amount and instruction is required.
No, no, we are admitting this appeal. We are not allowing the
Maybe,
appeal.
maybe. Lordship. Earlier 2 times it was dismissed for default.
Now, where is IA, has been allowed or not?
IA
For
lawsuit-
restoration?
Restoration has been allowed.
Already been restored, Lordship.
It is restored.
26/4/2020.
This court has dismissed for default.
Lords.
Court আছে এখন এইটো এটা endorsement থাকিব নালাগে নেকি নেকি
In 4/11/2022, this code, 22, this code also
এটা
dismissed.
থাকিব নালাগে হা এটা থাকিব লাগে না এটা ৰেষ্টৰিয়েচন অৰ্ডাৰৰ পিছত নেকি থাকিব লাগিছিলে Two appeals are there, or what? Are there 2 appeals?
Yes, sir.
Both of them are listed today?
Yeah.
Both were dismissed for default?
Yes, sir.
Lord,
Parties are almost same loss. Same
both
company.
are dismissed for default twice.
Okay. Heard Sri J. Kolita, Learned Counsel for the appellants. Appellant, in this appeal preferred under section 54 of the Land Acquisition Act, 1894 against an award, judgment and award dated, what is the date?
3/11/2021.
3/11/2021. Passed in reference
In
case number?
Miss Land Acquisition case number
Miss Land Acquisition case number?
3 of 12.
3 of 12. Both similar?
No loss. In 27, it is 2 of 12.
2 of 12. So 3 of 12, silable. Full stop. Para. Though, para, it appears that due to some communication gap and change of advocates, the appeal was earlier dismissed for default, which however has been restored to file. Full stop. Para. Admit. Call for the records. Sri Gogoi. T.R. Gogoi.
T.R. Google.
Learned State Council. Accepts notice on behalf of the sole respondent. Let extra copies. Have you been served? Sole respondent. Para, since copies were served earlier, comma, no formal notice is required to be issued. Mr. Kolita, the beneficiary is not here. Your appeal will go. ONGC will have to pay. It's not the state who is paying.
Because lordship, yes, ONGC has prepared another appeal, but thing is that lordship in the missed acquisition lordship, ONGC was not party.
Doesn't matter.
Yes.
You have to make them a
lordship,
party.
they have also preferred in that appeal lordship, we have filed objection stating that since they were not party in this case, lordship, so this appeal is not maintained. Same issue we have raised.
No, you have to make them a party. Ultimately, its collector is only the
Yes,
nodal
lordship.
agency through whom the acquisition is made. Payment has to be made by ONGC.
That mistake lordship, the first that it was.
You file an application, we'll allow it later
Lordship,
on. Okay. Last one, the Learned Council for the appellant prays for and is given liberty to file appropriate application for addition of further parties in the appeal. Okay. Separate, huh? And the reference order is the same?
Order is the same.
Only the case number is
Case
different.
number is
One is
20.
1 is 3.
2 and 3.
1 3 with asylum. Okay.
Master.
Wouldn't meet today, lordship. I have some urgency, lordship. After 3 p.m. I will be not able to hear, lordship. Tomorrow I can, lordship, if lordship. Any day, lordship, as per lordship condition. Lordship. No, lordship. One review is there. Lordship says lordship. Oblige, lordship. 41 and 42, lordship. Oblige, lordship.
Made reason. Lordship, there are 3 IAs in IA 236. Lordship, may peruse the office note dated 35/2024. Lord. Yes, Lordship. That is for delay control. Yes, Lordship. Yes, sir. Obliged, Lord.
My pleasure, Lord. As per your lordship order, lordship, I have filed my additional affidavit, which has been come on record. Matter is lordship arising out of a civil suit and against the informed order.
I am appearing for the, we have filed our objection.
Against additional equity
The addition, not a, I for condonation of delay.
delay.
Well, as per them, it's 772 days in filing the regular second appeal. No ground was cited in the application. That's why there was an order to file an additional appeal. Has been filed, but however, the ground so taken in the main application, it's not tenable because they have not justified the delay. They are taking the plea of Corona period, my lord. But the order was passed way back in the year 2017. In 1819, there was no Corona. And the learned registry also somehow calculated it, deducting the Corona period, came to a conclusion that it's 772 days delay. More. However, there is no plausible explanation is given as required for.
I am for the appellant petition. Plenty. Yes. Title appeal was this. Yes.
Just regular second
No,
appeal,
this is RSA.
not yet numbered because of the pendency of the.
It has not been numbered yet. Yes.
Yes, my lord, there is a serious objection.
Take some other date. Yes. Lovely.
Fine. Yes, my lord.
Thank you, Your Lordship. My lord, as per office number 14/5/24, the notice could not be served upon respondent number 2 as he could not trace out Lordship. In that place, Lordship. One is already appeared, Lordship. Lordship report is also annexed with this in the record. It is there, Lordship. Respondent number 2 is the owner of the offending vehicle. His address is Veluguri, Nagaon, Assam. No, Lordship. That's why I have seen in the memo judgment, Lordship. He did not appear. Service was complete, but he did not appear because there was no permit in the vehicle, no license in the vehicle. The case is that the owner is an important Lordship part. Lordship. Delay, Lordship, there's 76 days delay. Lord. Yes, Lordship. WC? Yes. Yeah. Received the notice, Lordship. Notice but failed to appear. Doiniko. Lordship, Lordship, can it be in the month of July, Lordship? Because here in the some procedure is there, Lordship. In the month of July, Lordship. Lordship, Lordship. That is appearance on 19th of July, Lordship. Must oblige, Lordship. Lordship. But because item 32 is a
Direction was
is a
by your
scope of
lordship.
contempt, Lord.
That's true.
Malo.
Bench 4.
Lordship, my lord, kindly scrutinize. I think Justice Surana, my lord, Justice Surana, it was has passed some order. It was perhaps that's why, my lord. I'm sorry, I just failed to indicate. Fine, my lord. Yes. Fine. Anybody, my lord? Deeply. Fine, my lord. Yes. That's yes, yes. Deeply.
My lord, the matter may pass over for the day, my lord. My senior is not well, my lord, suffering from high fever, lordship.
39.
Yes.
Highly
Lordship, today I have filed a written objection that may not be on record, Lordship. To the I for my lord restoration of a matrimonial appeal, my lord. For restoration. My lord. File today, Lord. Oblige. Oblige.
My lord, we have already taken a step. My lord. That is not. It is- I am for the only 1 to 7. 1 to 7. My lord, he was, they were engaged at the time of filing of caveat.
Subsequently, my lord, Uparatma filed by. Yes, yes.
My lord.
Rest I have taken a step, fresh step. They are not affected. Yes. Buddha way I have taken it's a Buddha way. Rest as well as no, I have no. Well, I kept there, I have no problem. We will get it. I- So actually, those respondents are performer dependent. They are not really they are also deep level. Those dependent not considered the sweet environment.
May I please. Small correction. Lordship, a small correction in the order dated 12/12/2020, Lordship. It is passed in our local Lordship. So, Lordship will kindly turn page number 30, Lordship. 30. So altogether, the claim was settled in 12 lakhs rupees. And initially, rupees 7 lakhs 19,775 was deposited before this registry Lordship, by the insurance company. And the remaining part, 4 lakh something was 4,80,225. That was deposited before the learned tribunal Lordship. And by this time, the claimant has already received it. Only because of an inadvertent submission on the part of the insurance company, the already deposited amount is not able to be released in favor of the claimant law. Page number 30 law. Inadvertently, this has been. Yes, Lord.
Lordship, we are for the appellant insurance company. No objection, my lord. We have already deposited the amount.
No, Lordship, the 4,80,000 is already received. Lord. We have annexed the order also. Lord. Lordship, as because of this observation, Lord, page 30, paragraph number 4, Lord. The insurance company submits that out of the settled appealable amount, 12 lakhs, an amount of rupees 7 lakhs 19,775 already been paid to the claimant. Not paid. Yes.
In fact, it was deposited before the registry. So, submission is that it was supposed to be before the registry, but somehow
inadvertently it has been
paid to the claimant. Paid, sir. Yes. Yes.
Yes, Lordship. We tried before the registry, Lordship, but after refusal, Lordship. Lordship. Registry. Lordship. Lordship. No, Lordship. Lordship. Lordship, 480,225 has already been released. Lordship. 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 And deeply honored.
Much obliged.
Obliged.
After 4 weeks, Lordship. Senior instructor. Then after 2 weeks. Much obliged.
We have filed an application under order 1 rule 10(2) for implementing the legal years of respondent number 4. Because they died before filing of the regular second appeal and after judgment and decree passed in the first appeal. Yes. Yes. This respondent number 4 died before the notice was already issued.
had, however, passed away before preferring this appeal and was a party in the original proceeding. Full stop para. Let notice be issued, returnable by 4 weeks.
But the learned counsel appearing for the respondent received the copy and he took notice of the last occasion.
Earlier.
Yes, he appeared on behalf of them.
Who's there?
Mr. P. Sundi, somehow due to some medical emergency, he could not
The
appear.
last order this court has been, however, this court has none appears for the respondent. Full stop. This court has, however, been informed that the learned counsel who was appearing is unwell. Full stop. In view of the above, list this case after 2 weeks. If he accepts, then we'll close
Yes, he
this.
has accepted.
Yes.
APJ Lord.
Yes, yes.
Lordship, please, I ask for condonation of delay of 10 days, Lord.
Notice has been issued.
Lordship, kindly produce office note dated 14/5/2024. Unserved notice has been received in respect of respondent number 1, Lordship, with the postal remark, no such person in the address. And for respondent number 2, Lordship, ID card has not been received. So for respondent number 1, I may be allowed to take step 1 for user post.
You're for the insurance company
Lordship.
against the WC.
Lordship. Only 10 days delay in filing it.
What is your prayer now? What do you want?
Okay, we'll take step 1. Respondent number 1.
And 2?
Lordship, service may be awaited at this time.
No, so you had taken steps when? Long time back.
On
23.
15/11/2023.
There's no point in waiting. You have to take steps again.
Then use the process, Lord.
Okay.
1 and 2.
In view of the office notes dated 15/11/2023 and 14/5/2024, comma. Your R. Sharma,
Lordship.
Sri R. Sharma learned counsel for the applicant is directed to take fresh steps for service of notice upon the said respondent numbers 1 and 2 by registered post with AD as well as by usual process. Steps within 3 days. List after the summer vacations along with service report.
Public.
Item 48.
May I please, Lord? Lordship will find the office note dated 35/24.
Yes.
My lord,
haven't said
usual
no.
process, my lord, 2 and 3 received by the brother-in-law, and 4 by the nephew, my lord. Unserved notice, my lord, neither ID card nor unserved notice returned back, my lord. So far, my lord, dusty service is concerned. As far as instruction, my lord, that has been refused, my lord. Then I will file an affidavit, my lord, with regard to dusty service.
You have taken dusty on all the respondents.
Only one, my lord, as per direction of this honorable court.
Respondent number 1.
Yes, my lord.
Okay. On the prayer of Sri R. Sharma, learned counsel for the appellant, comma, matter is adjourned by 2 weeks to enable filing of affidavit pertaining to dusty service upon the respondent number 1.
Public.
49.
It's one of those bunch matters, my lord, which were disposed of by common order. Petitioners, my lord, they were found to have acquired the qualification
yes,
of the
yes.
advertisement. My lord, I have one copy of an order.
Okay.
I have just marked out the
Have you checked
yes, my lord.
paragraphs, everything?
No, my lord, paragraph 5 of the order and page 79, paragraph 9 of the writ petition, the admission that they have acquired the DLF on 31/3/2019.
That's what about list along with A to D. Review petition 60 of 2024. Okay. How many respondents are there?
My lord, there are 15.
Respondents.
In that case, it was one.
Uh,
Here we have
Respondents,
15.
respondents or response service of respondents be taken by registered post VTD within 2 days. Okay, service report. List along with. It will look at. Okay.
No, bless you.
Judgment is the common
Common, sir.
1018. This would be 1018 WPC, no?
Yes. My lord, this is the case for restoration, my lord. But what happened in this case, after dismissal for default, matter has been settled amicably between the parties.
Okay.
So after restoration, I will not press this second appeal, my lord.
Why do you want to restore?
Because it was dismissed for default, that is why.
How does it matter if it is restored? If it is,
Oh, it may affect.
why? If you are ultimately withdrawing,
We are not pressing the second appeal on merit. Because it was.
we'll close this.
Yes.
We'll close everything.
After restoring, it may close.
Third, CBSK Ghost Learned Counsel for the applicant who by means of this Miss Case, you have filed for restoration.
One restoration, one condonation of delay. $95 days.
Who by means of this application, it I लिखिबा full is I to know MCA बोलेगा सर. Who by means of this ना miss के ठीक है. Who by means of this application MC लिखिबा 13 has prayed for readmission of the appeal which was dismissed for default on 22/9/2023. Full stop. The Learned Counsel has, however, informed this court that in the meantime, comma, the matter has been settled amicably between the contesting parties. Full stop. Para. In view of the aforesaid submission, comma, while the present Miss Case 13/2024 is allowed, comma, the connected RSA and IA number 609 of 2024 are closed. Full stop. Didn't I dispose of huh? In view of the aforesaid in terms of the aforesaid observation, all the aforesaid cases are closed. Yeah, but do want to go now? Okay.
Nice.
My pleasure, Lordship. Lordship, I have for condemnation of delay.
Yes.
884 days. Service has been completed, Lordship.
Service completed?
Yes, Lordship.
Has anyone appeared?
No, Lord. Service has completed last occasion.
Third.
A. Alim Sheikh, Lord.
Your name is not there.
Yes, Lordship, but we have signed Okalot.
You write, what is your name?
A. Alim Sheikh, Lord.
Alim
Sheikh, yes.
A. Sheikh, Learned Counsel for the applicant who by means of this application has paid for condonation of delay.
Yes, Lord.
Of
884 days.
884 days in preferring the connected appeal. Full stop. Para. Office note dated 4/5/2024 reflects that notices have been served upon the respondent numbers 1 to 10. And the said note has also been accepted by this court in its order dated 10/5/2024. Full stop. The respondents have chosen not to contest the application. Full stop. Para. The learned counsel has drawn the attention of this court to the averments made in paragraph 6 and 7 and has submitted that there were sufficient reasons which had prevented the applicant to prefer the appeal within the prescribed period of limitation. Full stop. Para. An application for condonation of delay is to be examined from the perspective of the grounds of delay cited and cited full stop in an appropriate case, comma, even the aspect of delay would be relevant if it is inordinate, if it is an inordinate delay, full stop. Para. It is a settled law that in adjudication of such application, comma, a pragmatic and justice-oriented approach is required. Full stop. Para. Considering the above principles and the reasons cited, comma, the instant IA for condonation of delay is allowed and the delay accordingly stands condoned.
Obliged.
Para. In view of the order passed today, that is so by which the application for condonation of delay in preferring the present application has been allowed, comma, the application may be registered and listed for admission expeditiously.
Right.
And 53 may appear the matter passed over some time ago.
IA for
lots for clarification. Order passed by order.
what clarification?
My lord had passed for interim order. This is my lord Nameri Ecochem's case. In the interim date was provided 10% will enter. When the matter was disposed of, that interim was made absolute. So again, they are before this honorable court. That clarification, my lord, in my humble submission, this clarification application is not maintainable. They have to come for review.
Will take the matter of some time.
After some time, it's finished.
Today?
Today, Lord. Otherwise, Friday, or Lord.
Friday.
Friday.
Or Wednesday?
When is the Lordship 14th, 5th, Lordship? There's some.
It's busy with poll, I think.
Poll is tomorrow, not Wednesday.
No poll, no poll.
He's waiting for after polls.
Celebration.
Lordship, apolitical person.
Not celebration, after effects of celebration.
After effects of celebration.
Celebration will be tomorrow evening. Hangover of celebrations. Appropriate
comment,
word. Appropriate word. Let us use the appropriate word. What is there to hide?
Friday.
Okay,
Friday.
On a prayer made on behalf of the applicant, list on Friday.
Right. All.
7/6. 54.
I file a IA, that is 1600.
Yes, for
Copy দিও না?
সকল টিকেট আছে টিকেট
আপনি কোন?
মই রেসপন্ডেন্ট ওয়ান
Mr. Bora, anything?
My lord, copy of this IA is not.
IFR.
IFR
amount
needs some sort of improvement over his business premises that is situated over the Suitland equipment.
IA, you are seeking directions.
I am actually, my lord, that is my livelihood. I'm running a shop, my lord. that
You are
is-
for Mr. Bora for?
I am for the respondent one plaintiff.
Plenty. Okay, serve my copy. We'll have it on Friday.
My lord, no, I have already started for Oh, there's another, yes. There's another council probably on.
I am for the respondent number 2.
Two. You're
Two
for
a
one.
receipt.
I am
Yes,
for
two
one,
receipt.
my lord.
You're not together.
No.
No,
No,
I am pro forma.
You're not friends or foe. Huh?
no, my lord, actually, we purchased from them. Original,
From Mr. Gwala,
Initially, I have purchased the land from the.
yes.
Mr. Bora.
Bra, and he sell to me.
Sell to my lord.
Then
Now I got a, by registered sale did I, my lord, I purchased it and I running a welding shop and that is my livelihood.
what is your problem then?
Now problem is that, my lord, he filed a suit to cancel the sale deed, which was first sale deed, my lord. And subsequently the second sale deed, which is sold to me, my lord. So ultimately, sale deed, my lord, my sale deed, which was registered one, my lord, that was been cancelled, my lord. That then in that count, the second appeal is pending. Suit was allowed, decreed, and there is a appeal also.
The registered sale deed in your favor
My lord,
by Mr. Gwala, that is also set aside.
Yes.
yes, my,
Both the sale deeds.
both the sale deed.
Initial sale, you had said it was done by fraud.
That was the.
So I am victim.
No, no, Mr. Bora.
Actually, no, what happened on
It
the
was
basis
an
of,
unregistered.
that was the unregistered sale deed. On the basis of the unregistered sale deed, he got the possession and mutation, everything. So that's why he is the recorded proprietor. I am purchased from him, but the permission also, my lord. So since original law is not proper, that's why it is.
He is somewhat high-handed, my lord, without any registered instrument. He
But,
got
you
I'm
did-
the victim.
and everything.
But you did not do due diligence. Where are the link deeds?
Yes, well, that's true. But necessarily, my lord, when there is a recorded proprietor,
No, that is not enough. You have
my
to
lord,
see, you have to see
My-
7 link deeds. You know what is the
my lord,
procedure
I
you have to-
understand.
not one.
But problem is this, my lord, I am victimized, my lord, because
And in other case, you will straight away come that records of right, Jamamandi is not
not a proper
not a
document.
title.
Only for self-purpose.
So, my lord,
Okay, you serve copy with
my lord,
Friday.
just my lord, I want to, my lord, just that CIC 10, my lord, that bamboo wall. So I,
You are protected by an interim order or what?
no, no, then they already, my lord, there's a,
Stay order.
the order is there.
Now?
Now just to running that my shop, because it is in a very bad condition.
Let him run the shop.
No, my lord, there is a problem. I am showing it
Okay,
to
okay,
you.
then we'll hear you.
Kindly, my
No,
lord,
no,
page
let-
number 8.
No, we'll hear you. We'll give
No, what
direct
is the
copy.
problem? I'm your light. He has a
There
right.
is a problem.
No, no, no. We'll hear the problems, everything, but not today, Friday. Let us.
Yes, my lord, yes.
It appears that Hertz-free TJ Mahanta runs in a conflict for the applicant. Full stop. Also Hertz-free B. Bora, learned counsel for the respondent number 1, and Sri H.P. Gwala, learned counsel for the respondent number 2. Full stop para. Though it appears, no, it appears that a copy of the IA has been served only upon the learned counsel for the respondent number 2. Full stop para. Ms. Bhattacharya, learned counsel assisting Sri Mahanta Senior Counsel, is accordingly directed
My lord.
to serve a copy of the IA upon Sri Bora, learned counsel for the respondent number 1, and the matter may come up for consideration on Friday. Date.
Publish.
Changes delayed, please.
Notice has not gone. Your name?
M. Hope.
Haj Sri M. Hawk, learned counsel for the petitioner, applicant who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay in 10 days, delay of 10 days in preferring the connected MSC appeal. Full stop. Para. MSC appeal against. Why do you draft this in a way? You don't haven't put anything about the Let me see appeal for enhancement of the compensation in the judgment and order dated 28/7/2023, passed in MSC case number 126 of 2020 by the learned MACT Gwalpara. Full stop para. Let notice be issued returnable by 4 weeks. Let steps be taken for service of notice upon the respondents by registered post with AD as well as by usual process. Steps within 2 days. List after 6 weeks. Published with service report.
56.
Yes.
It's an application for continuation of delay in filing appeal notice.
First time.
First time
Enhancement.
enhancement.
Same hobo, huh? खाली judgment and order hobo itu. 15/5/2023. MAC case number 178 of 2019. MACT Hailakandi. ঠিক আছে? Delay? That 10 days বলি আছিল নিকা কোটো. Delay of how many days?
88 days.
88 days ago. बाकी सब right. Take steps by registered post as well as usual process. 2 days.
Obliged.
57.
Please, Your Lordship.
Yes.
After this is an application for condonation for, and the delay is 103 days for preparing the connected CR.
CRP. আগৰ এমটা লুডৰ লিখিবা এইটো প্ৰথমটো কৰি লিখিবা এমটা Your name, madam?
MS V Rai. V Rai.
V Rai.
P.
V for victory.
Victory.
Okay, it would V Rai লিখিবা enhancement নহয় আৰু এইটো 103 in filing the connected CRP against an order dated 13/10/2023 passed in MS number, Manisut number 160 of 2017
And
by the
miscase number
by the learned civil judge senior division number 3 Kamrup App M full stop. Challenge has also been made to an order of the same date passed in Ms. J case number 801 of 2017, whereby the parties have been referred to arbitration. Full stop. How many days delay?
10.
103 লিখিছা উপর 103 হবো ওকে বাকি হ্যাঁ নোটিস 4 weeks registered post registered post just 2 days 6 service report yes take steps or registered post
deeply
59.
stay matter. What is stay matter?
Your Lord, I am the revision petitioner, my lord. Lordship has granted stay of the proceeding and my learned friend has filed an application for vacating the stay.
Okay.
For this is now.
Okay.
No stay vacating has been filed on my lordship. Your lordship can dispose it up. There be a small issue, but my execution has been stayed by this court.
You're the defendant.
No, I'm the judgment debtor.
The-
Decree was
I'm
passed
decree
ex
was-
parte.
That is, he's the defendant.
Yes, but
Defendant, you had lost the suit
Ex parte, man.
ex parte. Then you have you're armed with a decree And you have put to execution.
Yes.
Then what has happened?
Then Lordship CRP before this court granted us liberty to cross-examine Amin Commission and also to file a review application. Accordingly, we have filed one review and one petition under Order 26 for cross-examination of the Amin Commission. Review was allowed, cross-examination order petition was also allowed. Amin was also cross-examined. They have challenged, filed an application that in review, they were not granted any time to file objection. So they may be granted some time to end by setting aside the earlier order. Executive court says, Lordship, you have already filed your objection in Order 26 petition. And in that petition, you have objected review as well as Order 20. So that is not. So execution proceeded. They filed this CRP and execution proceeded.
Execution is a decree for what? Money suit?
Recovery.
Recovery. Money
Recovery
suit?
of, no, immovable property.
Okay, recovery of immovable property.
My lord,
There is nothing.
execution proceedings started. My lord, then, my lord, I came before your lordship, my lord, that without identifying the suit land, the decree has been going to be executed. Then your lordship remanded the case to the executing court, directing to first identify the suit land, then to proceed with the execution.
Okay. Yeah.
My lord, then my lord, landed trial court proceeded, my lord. Last Mondul gave a report to the ASO, Eastern Settlement. And then ASO submitted the report to the court. That report has been presumed to be a Amin Commissioner's report. My lord. It is not an Amin Commissioner. Amin Commissioner was never appointed, my lord. And more so, my lord, this impugn order has been for cross-examination of Amin Commissioner has been passed in Miss Case number 59 of 2022.
We can, if you both the parties are ready, we can take it up for disposal now.
Yes, Lordship can dispose it.
What is the next case? Yes, item 60. Who's there? 60. 60. Yes, what is your prayer, madam? Mr. Day, just while if doesn't take this matter doesn't take time, then we'll discuss. Yes, what is 60?
My lord, I have taken step against the opposite parties.
I am appearing for sole respondent, Your Honor.
Okay, what is this IA for?
Your Honor,
CRP. Okay. Interim order is there.
yes, sir.
Madam Das, you have appeared for the sole opposite party.
Sole respondent.
So what have you
Your
filed?
Lordship, I will be filing, I am appearing for the very first time, Your Lordship, so I will be filing our objection, Your Lordship.
Okay.
So kindly grant us 3 weeks time, Your Lordship.
What is the subject matter of dispute, madam?
Your Honor, the revision was filed against the order dated 13/12/23, passed in title suit number 131/21.
That is okay. What is the subject matter? What is the dispute about? We are not interested in numbers.
Vacating the ex parte order, Your Lordship.
You are the defendant in the suit.
No, yes, Your Lord.
Suit was declared ex parte.
Yes.
You had filed an application for
Vacating the ex
getting
parte,
an ex parte order. That has been
rejected.
rejected. Okay. Thereafter,
After I filed this present petition.
present revision petition.
Yes, Your
Dependent,
Lord.
Your Lordship, on the earlier dated, Your Lordship, that is title suit number 131/21, that the order dated, Your Lordship, 26/11/21, ex parte order has been passed, Your Lordship, where defendant had given enough chances, Your Lordship, to
Just a
file.
minute, madam. Madam, how will a revision lie?
Your Lord.
How will a revision lie?
Lordship, I filed this against the ex parte order which was rejected by the civil judge number.
See, you are the defendant, right?
Yes.
The title suit is what? What is the title suit?
Title suit was filed for declaration.
No, number?
131/21.
21. You are the defendant. It was decreed ex parte.
Yes.
When?
26/11.
26/11?
21.
21, the ex parte decree.
Yes,
You were not informed about the decree, okay?
Your
You are not
Lordship,
informed about the
That was
proceeding.
not decreed,
No, your lordship, a notice has been served.
Just a minute.
but
You said that you are not, you did not receive notice.
no,
It was
your,
an- It was
no,
an ex
your,
parte. Then,
your lordship, the defendant was a lady who did not know.
okay, we are not on those. You thereafter filed an application to vacate ex parte.
Yes,
What was the application? MC what? Ms. J case number?
ex parte vacating
Ms. J case,
Ms. Z case,
page.
page. That's it, petition number. 38 to 41.
30,
38, page number 38 to 41.
38.
Petition number 2445/22. Petition number 32 is
Seven. What order? 26. You had filed for order 9, rule 7.
Yes, your lord.
That means there was no ex parte to final order. It was only fixed for ex parte hearing.
Yes.
You had come at that stage,
Yes,
stating
your
that it should be vacated and it should be given an opportunity of
filing WS.
WS. Then what has happened? What order was passed? Where is the interim order?
51. Page number 51.
51.
51.
Yes. Okay, you file your objection then.
Yes, your lord.
Let her file the objection. Okay. Madam, what is your name?
Manjushri Patri.
M. Patil.
Patgiri.
Padgiri.
Yes, sir. Yes,
Pat-
your lord.
Ms. M. Padgiri, learned counsel for the petitioner. Whereas Ms. P. Das has appeared for the respondent. On the prayer of Ms. Das, the learned counsel. Matter is adjourned by 3 weeks or 4 weeks? 4 weeks to enable filing of objection affidavit. Okay.
Deeply objects.
I have annexed the expertise judgment, my lord.
No, let us start from the beginning. Who are you?
I'm the defendant.
Defendant.
Mine.
Petitioner is the defendant. Suit for?
Suit for declaration, my lord, I have not. Next, the plain, my lord, suit for declaration and
It
recovery.
doesn't
of
matter.
position.
Declaration and recovery.
My lord,
And recovery of position.
my lord.
Yes, what has happened?
Degree they have annexed.
And
Degree is
I
there.
annex at page 13, my lord.
No,
It
then
is an
what has
expertise
happened?
decree, my lord, it was decreed,
Expert decree.
my lord.
Dated
Lordship written
Dated
statement filed.
37/2019.
registered and filed.
Yes.
But not contested thereafter.
Lordship.
And expert decree dated
37/2019.
19 expert decree. Okay, then what happened?
My lord, then my lord,
Decree given for execution.
decree put on execution. My lord, execution number is 10/2022.
22, okay.
I'm sorry, my lord, 10/2019.
19.
My lord.
Okay, doesn't matter. Okay, 19.
Then, my lord, they came before your lordship that the decree has been put to execution without identifying the land.
Who
My
had,
your lordship, or your lordship.
who
asked-
came?
my-
They came, Lordship. Page
we,
31. They came.
Achha,
your lordship's order.
you had approached whom? Which court?
This court.
Your lordship, my lord.
Okay.
Page 31. Yeah.
Mm.
The operative portion is at page, my lord. Page 33.
31.
Here I at the bottom, my lord.
CRP 13 of 21.
My lord.
Page 31. Yes. What happened?
Uh,
At 33.
33, my lord, and para bottom, my lord. In view of the joint agreement of the parties herein to that effect, they have no objection if the executing court first identify the decreted land before the issuing process. I am disposing of the instant petition with a direction to the executing court to identify the decreted land in that regard. If necessary, the executing court to take reference to the judgment of the Honorable Supreme Court in the case of Pratibha Singh and others versus Constitution, and thereupon proceed with the execution of the decree in accordance with law.
Yes.
Thereafter, my lord, the trial court, executing court goes to identify the suit manner. A Mondal has given a report. It is at page 35.
Date?
My lord, date 25/11/2021.
Yes.
Page 35 is the Mondal report, my lord, to the Assistant Settlement Officer, Mankachar Revenue Sector. My lord, Mondal has reported that the suit land is not identified. My lord, his report, my lord, it is 37, my lord.
Yes.
Is 37, paragraph 5.
Which part?
Assamese version also there.
Page 37, paragraph 5.
My lord, the dimension of the land is not possible as per the record because the description and
Yes, yes,
boundary.
okay. Then?
Then, my lord, then ASO submitted that report in the executive court. My lord, on perusal of this report, my lord, the executive court dismissed the execution process.
Yes, so furnished this report to court.
My lord, and it was execution proceeding was dismissed on 15/12/2021.
Page 40,
Page 40.
execution proceeding dismissed.
My lord. And that suit land is not on the ground that the suit land is not identified, considering the Mondol.
Okay, then,
Thereafter, they approached your lordship, my.
yes.
And your lordship's order is at page 45. Lordship passed order on 6/6/2022, my. Page 47. But after hearing the matter at length, the learned
At
counsel.
page 47.
Page 47. After hearing the matter at length, the learned counsel for the petitioner submits that taking into account that no objection was filed to the Amin Commissioner's report, as well as no application was filed seeking cross-examination of the Amin Commission, he would like to withdraw the state petition with liberty to the instant petitioner to file a review application along with other applications as is required under the law. Ms. Chaudhary further submits that the period during which the instant matter has been pending before this court may also be excluded while completing the period of limitation for the purpose of filing the review application. I have heard the learned counsel for the parties and given my anxious consideration to the matter, taking into account that it is the mandate of law that if any person is aggrieved by the Amin Commissioner's report, the law provides a right upon him to ask for cross-examination of the Amin Commission and also to file objection to the same, and the same having not been done on account of the advice received by the petitioner, this court permit withdrawal of the instant application, thereby granting liberty to the petitioner to approach the executing court for filing an application seeking review to advice.
Okay.
My lord, thereafter, my lord, they filed Miss Case number 59/2022 at page 49. My. This was filed on 22/6/2022, page 49.
Yes.
An objection under order 26 rule 10(3) read with section 151 of CPC by the decree holder against the report dated imminent.
Yes.
But there was no execution proceeding, but because it was dismissed earlier. Then, my lord.
Yes.
I also file objection, my lord. Then thereafter they filed restoration of title execution, my lord. It is at page 59 on 16/2/2023, page 59. Just they filed and then the court passed order on 16/2/2023 as page 59, my lord. This is the restoration of execution proceeding, my lord. The operative part is at page 66, my lord. The review petition is allowed.
This is for restoration.
Restoration of the execution proceeding. Page 66, man.
Restoration is allowed.
Restoration was allowed.
Yes.
Restoration was allowed. After that, my lord, the impugn order has been passed on 6/1/2024. Is at page 77. Seven.
Yes.
Your lordship kindly see the top, my lord. Miss J 59/2022.
Yes.
And the date is 6/1/2024.
Yes.
Then operative part is at page 81, man. Hence, considering the entire facts and
At page?
Page 81.
Hmm.
Hence, considering the entire facts and circumstances of this case, the prayer of the petitioner decree holder stands allowed. The petitioner decree holder is directed to take steps against the Amin Commissioner for his cross-examination. This I have impugned in this division.
Okay, understood.
So, my lord, my ground is two, my lord. Number one, my lord, Amin Commissioner was never appointed. And the report, that is a Mondal report, it was submitted not to the court, but to the ASO. So no question of cross-examination of Mondal.
Why Mondal cannot be cross-examined?
No, my lord, it was not submitted and filed before the court, my lord.
No, ultimately the report, the execution case was dismissed on the basis of a report which says that the suit land was not identifiable.
Right.
Now that report, you contend that it was not through an Amin Commission.
Amin Commissioner.
It had emerged from a Mandal.
Mandal.
Now, the court has, by the impugned order, given them, allowed their petition and asked them to take steps for having the Amin Commissioner in the court for cross-examination. Amin Commissioner has to be understood that it is the Mandal who is the report.
No, my lord, it is not.
ASO was summoned by
Who will
executing
come
court.
to you?
Sorry.
What is your second ground?
My lord, for cross-examination of Mondal, my lord, they have to take steps as per CPC, my lord. That separate procedure is there. So that has not been followed. Amin Commissioner, if the court has appointed Amin Commissioner, I have no objection, my lord.
No, even we have not heard Madam Chaudhary, that we do not know what will happen. But the report of the Mandal had come not during the pendency of the suit.
My lord.
It came at the time when the decree was put to execution.
My lord.
And according to the Mandal report, the suit land was not even identifiable. And so execution was,
my lord,
the case was rejected. There is not executable. Thereafter, matter came to this court by them, by you. Ultimately, court granted them liberty, and you approached the trial court. They had approached. Now you are trying to say that their contention that it is based on an Amin Commissioner's report is not correct.
No.
There was never any Amin Commissioner appointed. That is your first contention. Second,
if the Mondal is to be examined, he has to be examined as a witness. They have to take steps for his appearance before the court. He could be examined as a witness, not as an Amin Commissioner.
now what difference will it make?
My lord,
Substantially, what difference will it make? We are not even knowing.
Your lordship knows, my lord, in the CPC, my lord, there are separate procedure for appointment of Amin Commissioner and calling as a witness.
No, not on the aspect of who has done the spot verification, whether it is by an Amin Commissioner, whether it's a Mondal report. The purpose of this court in remanding the matter or giving them liberty to ask for a remand is to enable the parties to cross-examine whoever has given the report.
Exactly, my lord, but the procedure has to be followed, my lord. They have to file an application for appointment of Amin Commissioner if they want to that, my lord, or to call the
Now, if
witness.
instead of the Amin Commissioner, if the Mandal is cross-examined, what is the prejudice you are going to suffer? Ultimately, the purpose, objective of the court is to arrive at the truth. If the court, after all these years of trial, decreeing the suit at the time of execution says that the decree is
my-
not executable on the ground that the suit land is not identifiable based on a report by the Mandal. And they were not given a chance to cross-examine, whoever is, I mean Commissioner Mandal. Then giving them a chance to cross-examine, and not only them, you will also get a chance.
I may not suffer any prejudice, my lord, but procedure has to be followed. Procedure has not been followed.
What
my lord.
procedure not followed?
Procedure, my lord, I mean, they want to examine, cross-examine, I mean, commissioner. I mean, commissioner never have been appointed. They have to
No,
file an
yes, yes,
application for
madam,
appointment
yes,
of, I mean,
yes.
commissioner. my
What
lord.
is your stand?
My lord, second argument is there. My lord, the execution case was dismissed on 15, my lord, and will note down the date, my lord. It was dismissed on 15/12/2021.
Yes.
And my lord, the order, impugn order has been passed in mistake case number 59 of 2022, which has been filed on 22/6/2022. It has been filed after 1 year of the dismissal.
Now, this is in accordance with the High Court's order.
Now, High Court directed them to file and review.
Review, yes.
Review. They have not filed the review. They have filed the objection against the report. It is an objection, my lord. It is mistake case number 59 of 2022. It is not review. High Court directed them to file review. They have not filed. Review was filed afterward. So, my lord, when this 59 of 2022 was filed, the execution case was not in existence. How an order could be passed in this case?
No, this order has been passed when? On 6/1/2024.
My lord.
After passing of order dated 16/2/2023.
No, the miscase was filed after dismissal of the and then the execution proceeding was restored after after filing of mistake case 59 of 2022. In between, yes, my lord.
No, during the pendency of 59 of 2022.
My lord.
They had also filed Ms. J case 22 of 2023.
22 filed by them.
Oh, 22 filed by
by
us,
them.
man.
Yes.
Lordship, may I
They have
make it
not.
clear, Lordship? After High Court's order, we have filed two petitions, 68 and
We
69.
filed 22 of 2022 for setting aside of the restoration order.
'59, who has filed 59? Please.
59 we have filed, Lord. As per-
59 you have filed?
Yes, Lord.
Not you.
22 they have filed.
No.
There are three mistake cases, Lord.
Okay.
59 for cross of Amin Commission, Lord.
59 is a page, my lord.
49.
No, at page 59, madam. Midge 22 is by you.
22 is by them, Lord.
Why?
22 for setting aside of the restoration order, man.
The petitioner, the decree holder. Who is the decree holder?
No, Lordship, that is 16/2/23.
Yes.
By this order, I am going to dispose of this instant Midge case, which has arisen from Midge case 59.
Okay.
It has arises from 59, as our 59 was allowed by the learned executing court. So they filed Midge 22.
Where is 59?
59 page
is-
49, your lordship will find.
So can you see, it is not a review, my lord. So on this one, your
And
lordship directed to
59
file a review, but it is
allowed-
not a review.
59 was allowed by order dated 6/1/24, that is page 77.
Yes.
59 was allowed, Lord. And we have filed another application, that is 68, Lordship. This is 68, 59 Midge case is petition number 68. And another application number 69, which has been registered as 47, Lordship.
Midge 47.
Midge 47, Lordship. That is page 71 and Annexure 10.
No, either you refer to the petition numbers or Midge numbers.
sorry,
It will be
sorry,
otherwise
sorry,
confusion.
Sorry, Lordship. Midge case 22 is by us. Your Lordship is correct. That is our review petition, Lordship.
That is what I was trying to say,
Lordship, Lordship.
because that has been allowed for
Yes,
restoration.
that is our petition number 69.
Yes.
Lordship. Our petition 68, 69, both were allowed. Mid-J case
Yes.
22 and
And
59.
now what we are trying to show to Mr. Day
My lord.
is that the order of 6/1/2024, though it was passed on with Ms. J 59 of 2022, which was filed earlier in point of time,
Correct.
in the meantime, on 16/2/2023, Ms. J 22 was allowed.
Yes, Lordship.
So
They-
therefore, there is a
Mid-J
sequence.
case 59 was kept in abeyance, Lordship.
Understood?
Lordship. It was
Because
reflected.
unless you can.
Review is allowed,
Yes,
Lordship.
unless review is allowed.
Lordship.
My lord, my argument is this, my lord. 59 of 2059 has no existence, my lord, because the execution proceeding was not there. It is dismissed earlier. While it was.
No, execution proceeding was not there, you are correct, but is there any order passed in Ms. 59 of 2022 before it was reviewed? No order was passed.
My lord, that could be seen from the record only, my lord.
Obviously, the order which has been passed in Ms. J 22 of 2023, which
So, my
is for
lord,
review.
So, my lord, my application will be, my lord, the lordship may examine the record, my
No,
lord.
no, we are having the, come to page 59. Please come to page 59. 59. This is what, Ms. J 22 of 2023, correct? No dispute? Correct?
Correct.
Come to the fourth line. The other, this third paragraph. Decree holder has filed this petition under order 47, section 114. This is the application for review. Your contention is that unless review is done, no order could have been passed.
But this
in
is.
59.
But this is wrong, my lord. This petition was not filed under order 47.
This is filed under
It was
47.
not filed, my
Why?
lord. My lord, your lordship has seen, my lord, page 59, my lord.
Page 59 is the order.
My lord, not page 59. Yes, 49, page 49. This is the
49.
49. This is the application of Ms. J 59. man.
Again,
My
this
lord,
is not
an
22.
objection under, my lord. Your lordship can.
This is not 22. This is 59.
Yes, 59.
We are on 22. What is 22?
But the impugn order has been passed in 59. my lord.
No. The
My
order
lord,
is
your
passed in
lordship
for 22.
My lord, impugn order, my lord, 6/1, my lord, has been passed on.
16 to 2023 is passed in 22.
I have not 16 to, my lord, it is not there, my lord. 59 of 2022, the impugn order 6/1 2022.
Yes, 6/1/2024 after it is reviewed. The review was already done on 16 to 2023.
These have considered the Mondal report, the PT objection and the counter objection. This order has been passed considering the objections only, my lord, not review application, my lord.
Review has already been allowed on 16 to 2023. Why should a review be allowed to on 2 occasions?
My lord,
This
review.
case 2022 of 23 was allowed at page 59.
Yes, my lord, it is allowed on 16 to 2023.
Yes,
But
thereafter-
but 59 was filed on.
It's not a question of filing. 59 was filed, as you have rightly contended, when there was no execution case. Thereafter, keeping 59 pending, they had filed Ms.J case 2022 of 23 after almost 1 year.
My lord, how could it be kept pending, my lord?
It doesn't matter whether it was pending or it was filed afresh. That was not taken into cognizance. At times, in this court, delay condemnation, we cannot take cognizance. But still, with the delay condemnation, they file an appeal. Appeal lies there. No orders passed. And had it been a case that without restoring application, some orders were passed, matter would have been different. Here, though MISJ 22 has been filed at a later point of time, this has been disposed of at an earlier point of time than 59. 59 has been disposed of only on 6/1/2024, whereas 22 has been disposed of on 16/2/2023. Now, Madam, what is the aspect of this Amin Commissioner and Mandal?
Lordship, he was cross-examined.
Who?
I have the certified copy,
Who?
not Mandal.
Mandal.
Lord-
So why is the
And they
expression Amin?
cannot raise
No, why is
objection.
the expression Amin Commissioner used?
Lordship, Amin Commissioner ASO. He was appointed as the Amin Commissioner to demarcate the lands and to identify the land, Lordship. And thereafter, ASO provided the task to the Lot Mandal.
Okay.
So Lot Mandal on field verification submitted report to his predecessor, Lordship, that is ASO.
Just a minute, please. You say that Amin Commissioner, the ASO was appointed as the Amin
Yes,
Commissioner.
Lordship.
Where is
They
the
did-
order?
They did not raise any objection, Lordship.
Is there any order?
That is order page 33, Lordship, where High Court joint prayer made by both the parties for identification of the suit land. And thereafter, Lordship, the Amin Commissioner was appointed and his report was at page 40, your Lordship will find the dismissal of the execution proceeding. 15/12/2021. It reflects that the report from the ASO Mankasar Revenue Circle is received along with his reply to the show cause notice issued by this court.
He sought an Amin Commissioner sought the report from the Mandal.
Yes, Lordship. The concerned Lot Mandal in his report has submitted.
Okay, thereafter you had, now what is the
So
stage?
as per High Court, Lordship, we have filed review and Lordship one cross-examination of the
Okay.
person who
Okay.
identified the land.
Now you have cross-examined him.
Yes, Lordship.
When?
He was cross-examined. I have the certificate.
Cross-examination of whom?
Lot Mandal, Lordship. He said, I have come to the court after being deported by the ASO. So the ASO have power to deport Lot
Okay.
Mandal, Lordship.
Done.
Yes. Lordship,
When
that
was it done?
22nd day of February 2024, after this order, Lordship.
Okay, then
Then, Lordship, the case is at the stage of last impugn order. Annexure 12 is the last page order, page 82.
Hmm.
Fix 22/2/2024 for cross-examination of the Amin Commissioner. So accordingly, he was cross-examined.
Yes.
And then there is a stay from court. And Lordship may go through this Pradeep Mehra judgment very recently, 2023. Lordship. And Lordship, in this case, they have filed their written statement and thereafter they remained absent. They did not adduce any evidence. They did not cross-examine the PW. And thereafter, now they are disturbing in the execution proceeding. Lordship. Page 17. Para 7, in support of her claim, the plaintiff adduced evidence of 3 witnesses, including an official witness. The contesting defendants failed to cross-examine any of the PWs as they defaulted in their appearance. Altogether, thereafter, the plaintiff's evidence was closed. On their part, the defendants failed to adduce any evidence in spite of being granted sufficient opportunity for the same. So, Lordship, para 5 in their written statement. So, defendant filed their written statement. Thereafter, they remain absent willfully.
Okay. Okay.
Now they cannot raise objection. Lordship. Again and again, Lordship, they are harassing the
Now what
degree
is the citation you are trying to rely
Lordship,
upon?
that is 2023 Supreme SC 1089, Pradeep Mehra case, Lordship.
1089.
1089. I have a copy. Lordship.
What has been stated?
Here the head note says inordinate delay in execution of decree remedy for preventing injustice. Pure civil matters take a long time to be decided and it was not end with the decision, as execution of a decree is an entirely new phase in long life of a civil litigation. Executing court can never go behind decree. Under section 47 CPC, executing court cannot examine validity of order of court which has allowed execution of decree in 2013. Unless court's order is itself without jurisdiction. Execution proceeding works in different stages, and if judgment
How is that
letter-
relevant to you?
As because, Lordship, they have never raised objection in the, while the executing court was
No,
calling ASO's
in
report.
this proceeding, how is it relevant to you?
Lordship, res judicata will come, Lordship. Now they are taking the plea that he is
Res
not
judicata?
affected. In the same proceeding, res judicata will
This will not
come,
help
Lordship.
you.
they cannot raise this
This will not
objection.
help, this will not help you.
Lordship.
That's
And
all.
Lordship, there are several decisions which says execution to be done in accordance with decree. Executive court cannot
Okay,
go
okay,
behind.
no, no, otherwise also this matter may not be maintainable. Okay. Recourse to Article 227 of the Constitution of India has been taken to impugn orders dated 6/1/2024 and 22/1/2024 passed by the learned civil judge, Junior Division, Hatsingimari, Dhubri, in Miss J case number 59 of 2022 and title execution number 10 of 2019. Full stop. Para. To understand the issue involved, it would be convenient if the brief facts of the case are narrated. Full stop. Para. The petitioner is the defendant in the suit being title suit number 118 of 2016, which was for declaration and recovery of possession. Full stop. The suit was decreed ex parte on 30/7/2019, and the plaintiff decree holder had filed execution case number 10 of 2019. Full stop. Since there was certain anomalies in the identification of the suit land, the present petitioner had earlier approached this court in CRP 13 of 2021. Full stop. The said CRP was, however, disposed of wide order dated 1/11/2021 on a consensus arrived at by the parties that before execution, the land in question would be identified first. Full stop. Subsequent thereto, a report was called for by the concerned ASO, whereafter, such report was submitted by the concerned Lat Mandal on 25/11/2021. Full stop. In the aforesaid report, however, it was stated that the suit land was not identifiable. Full stop. The report was accordingly furnished to the learned court and consequently, wide an order dated 15/12/2021, the execution proceeding was dismissed as the suit land was not identifiable. Full stop. Para. At that stage, the present respondent, within bracket plaintiff, had approached this court by filing CRP IO 43 of 2022. Full stop. The said case was disposed of by this court wide order dated 6/6/2022, wherein the present respondent was given liberty to cross-examine the Amin commissioner and also to file objection. Full stop. It appears that thereafter, Ms. Case of 59 of 2022 was filed by the present respondent under Order 26, Rule 10 within bracket 3. Full stop. Thereafter, Ms. J case 22 of 2023 was filed for review of the earlier order dated 15/12/2021. Full stop. The application for review registered at Ms. J 22/2023 was allowed by the learned executing court on 16/2/2023. Full stop. Thereafter, by the impugned order dated 6/1/2024, Ms. J 59 of 2022 was also allowed, whereby the respondent decree holder was directed to take steps against the Amin commissioner for cross-examination. Full stop. Para. It is the validity and legality of the aforesaid orders which are the subject matters of challenge in this proceeding. Full stop. Para. I have heard Sri K.K. De, learned counsel for the petitioner, whereas the respondent is represented by Ms. R. Chaudhary. Full stop. The materials placed and record have also been duly considered. Full stop. Para. Sri De, the learned counsel, has submitted that unless the execution case was restored, the powers under Order 26, Rule 10(3) could not have been invoked. Full stop. It is submitted that at no point of time any Amin commissioner was appointed, and therefore there was no occasion to call for such Amin commissioner for cross-examination. Full stop. It is also submitted that if at all there was a report, it is the report of the Mandal, and such Mandal, if required to be examined, has to be done by calling him as a witness and not by the procedure adopted. Full stop. The learned counsel accordingly submits that the impugned orders are liable to be, are not sustainable in law and liable to be interfered with. Full stop. Para. Per contra, Ms. Chaudhary, the learned counsel for the respondent, has submitted that the instant petition is nothing but a procedure adopted to further delay the outcome of the execution proceeding. Full stop. It is submitted that the title suit was instituted in the year 2016, in which the present respondent had initially contested by filing written statement. Full stop. However, after such filing, the petitioner as defendant did not stopped appearing. Full stop. The petitioner had also failed to cross-examine the PWs and did not adduce any evidence in spite of opportunities. Full stop. The petitioner as defendant also did not advance any arguments, and ultimately the suit was decreed on 30/7/2019. Full stop. Full stop. The learned counsel has also clarified that though the petition under Order 26, Rule 10 within bracket 3 of the CPC was filed prior in point of time, the same no effective orders were passed in the said petition, and it was only after the order dated 16/2/2023 passed in Ms. J case number 22/2023, whereby the earlier order dated 15/12/2021 was reviewed, the Ms. J case 59/2022 was disposed of, wide order dated 6/1/2024. Full stop. The learned counsel accordingly submits that there was absolutely no violation of any procedures or the requirements of law. Full stop. As regards the aspect of the Amin Commissioner, the learned counsel for the respondent has submitted that the ASO was indeed appointed as the Amin Commissioner at the time of execution of the decree, who had called for a report from the concerned Mandal. Full stop. The learned counsel has also informed this court that in terms of the order dated 22/1/2024, the petitioner had taken steps for calling the concerned officer for cross-examination, and on the next date fixed, that is 22/2/2024, the concerned Lat Mandal was cross-examined. Full stop. It is only thereafter that, pursuant to the order dated 23/2/2024, that further proceedings have been put on halt. Full stop. Para. The Ms. Chaudhary, the learned counsel, accordingly submits that the present petition is liable to be dismissed, as filing of the same is only to further delay the proceedings. Full stop. It is submitted that a decree holder cannot be denied of the fruits of the litigation, and in any case, the endeavor of the court is only to arrive at the truth. Full stop. The learned counsel for the respondent has relied upon the judgment of Pradeep Mehra versus so-and-so, reported in so-and-so. wherein the aspect of inordinate delay in execution of decree has been discussed. Full stop. Para. Upon hearing of the parties on perusal of the materials on record, comma, this court is of the opinion that while the learned counsel for the petitioner may be right in contending that without there being an order of review of the order dated 15/12/2021 and consequent restoration of the execution proceeding, comma, no order could have been passed in allowing the respondents, decree holder, to have the Lat Mandal as an to cross-examine the Lat Mandal by taking steps, comma, it is clear that though the application under Order 26, Rule 10, within bracket 3 of the CPC, which was registered as Miss Case 59 of 2022, was filed earlier in point of time, comma, the orders passed thereon on 6/1/2024 is after review/restoration of the execution petition on 16/2/2023, full stop. The present respondent, decree holder, during dependency of Miss Case 59 of 2022 had filed Miss J Case 22 of 2023 for review/restoration of the execution petition, which was dismissed on 15/12/2021, full stop. A bare perusal of the said order dated 16/2/2023 would make the aforesaid position clear, and for the sake of clarity and for this clear, full stop, for ready reference, comma, the relevant observation of the learned trial court on the aforesaid issue is extracted here and below, page 59. Full stop. Para. Once the order dated 16/2/2023 was passed by the learned trial court, comma, the execution case was restored as the earlier order of dismissal dated 15/12/2021 was reviewed, full stop. After such restoration, comma, it cannot be argued that the subsequent order dated 6/1/2024 has been passed without jurisdiction, full stop. This court has also noticed that in terms of the order dated 22/1/2024 of the learned trial court, comma, the concerned Lat Mandal was cross-examined on 22/2/2024, which was the date fixed, and thereafter the matter is put to a halt because of the interim order passed by this court, full stop. Para. The suit having been decreed by judgment and decree dated 30/7/2019, and the said decree not being put to challenge by filing appropriate appeal, comma, The present procedure adopted by the petitioner at the state of execution does not appear to be with any bona fide intention. Full stop. Though it would be open for any party to raise objections in accordance with law, comma, in the instant proceeding, comma, no illegality is noticed in the procedure adopted, comma, more so in terms of the earlier orders passed by this court in CRP IO 43 of 2022. Full stop. Para. In view of the aforesaid discussion, comma, this court is of the view that the present petition is without any merits, and accordingly the same is dismissed. Full stop. Consequently, the interim order dated 23/2/2024 is also vacated.
Probably one thing, the instant suit is decreed on contest with court, was not decided expert. The first, your lordship.
Okay.
The expert that pays.
It is their, it is their projection,
Lord.
Eric Lieber. The learned counsel,
Page 28
the
of
learned
the-
counsel for the respondent has also clarified that the decree is,
Suit is decreed.
the suit is not an the decree is not an ex parte one, but was decreed on contest
With cost.
with cost.
I'm deeply operated.